Hello, Grizzlies. What is up? Sorry, here I am. I have decided to go live a little bit sooner because I can see things. I'm looking at WFLA. I'm looking at Doug, live from Northport. Thank you, guys. The beat is fire. So, yeah, I mean, I have no idea what we're going to see. That's what I was worried about. What are we going to see? Should I even stream? However, I can already see a lot. Right? We can actually see them in court. And I'm like, what? So let me just quickly look over here. Yes, Doug. Okay, so if we look here, I'll show you now. I've just muted it for now, but I'll show you. Like, we can literally observe them in court. What? This is amazing. I hope the Petitos are able to take this to court. I really, really hope so. Of course, they're going to start at... it's 7:30 p.m. my time, 1:30 p.m. Eastern time is when the hearing actually starts. So right now, this guy is so cool, Peter Tragos, the lawyer you know, and of course we've got JB as well, and they're just talking it out, of course. So I'm not playing it right now, but yes, you can see Gabby Petito's dad, mom, stepdad, stepmom. I can't see the Laundries. Are they in there? Are they in there? Yeah, I'm dressed for court, everyone. You know, I get dressed for court. So yeah, let's just see what they say here.
Some new advancements here with our hashtag-based system. We're going to start to introduce questions and comments if you use the hashtags on your screen in the comment section.
Okay, so disclaimer, this is WFLA's content. I would never dream of taking them on in any legal matters. If you don't know what I'm talking about, don't worry about it. But yes, this is their content. I'm streaming it because I love WFLA, love JB, love the lawyer, you know. Can't believe they have him on today as well. And also, it's a public event, and I'm not too sure where else to stream it from. But I'm here with you guys to experience it with you. Of course, if you want to go watch it over there, do that. But man, this is for like commentary, running commentary of what's going on. I mean, Gabby's dad looks like he's ready for business. He's looking like an anchor, you know, all chilled. I mean, like an anchor in a storm, you know what I mean? Not like a news anchor. He's looking calm. He's looking centered. He's looking ready. You know what I mean? Yes. Why can't they show? Are the Laundries there or what? Why can't they show us? Hello, Claire. Here we are again, Claire. Here we are again. It feels like we're right back in the case when this happens. Oh, my word. Yeah, he's ready to bite. He's in Grizzly mode, everyone. That's what I can see. She's wearing shorts? Who? Who? Oh, yeah. Look into the camera. What can we see? Let's quickly... Laundries will not be there? Why? Just the lawyer? Or what? Sorry if I'm talking loud. I'm very excited. I'm just quickly going to take this off screen because I want to quickly see here this Doug video that he put up. Doug from Northport. Yeah, let's look. Wait. Video too quick for me. There we go. Okay. They can't get in because the doggy door is locked. Ramona. They can't get in because the doggy door is locked. Yes, we are here in court, G. Get our Grizzly books out. I know, Claire. We are live from the courtroom. Right? Wow. So nice to see you guys here. Yeah, because they are cowards. But seriously, why don't they have to be there? I don't understand. I don't get it. Why don't they have to? Does anyone know? Why the hell don't they have to be there? Oh, yeah, for their own personal protection. This is horrendous. They didn't have to be, so they're not. Chickens. I mean, it really doesn't make them look good. So let's quickly look at, shout out to Doug from Northport. His channel's still going strong. Love it. Love to see him drive around. Slushy time. He also calls it like time. You know, here we do like waffle time, map time. He's got slushy time. So the lawyer speaks for them. That's horrible. So let's look at this quick clip that he's put up for 2 minutes of them walking in. It's a little bit like glitchy. The security going on. Okay, we can see that. It's buffering on Doug's side, by the way, guys. So sorry, it's a bit buffery. Okay, now we can address it. Gisela, be careful streaming JB. They are suing Jace for justice for using their channel to stream Gabby Hunt. Okay, that is not why they're suing them. So cool. Thank you for someone for mentioning it. Now I can finally explain it. What happens is, behind the scenes, if you stream something, you might get a copyright claim. If you get a copyright claim, you have a few options. You could either take your video down, you can accept that, yes, they can earn all the money, or you can dispute it and say that content is mine. Unfortunately, I think that's what happened based on everything I've read on that case, is that the content creator said, no, that content's mine. Fair use is a tricky game. Like fair use, you have to talk every 7 seconds or so. Okay, you got to talk. Yeah, we're spilling some tea here. Normally we do this behind the scenes. You got to talk like every 7 seconds, but it doesn't guarantee it. The content creator can still say, no, that's our content. And all it does is take all the money earning potential away from you. That's it. So there's been times when that happens. Like if you show a Dr. Phil clip, and I'm talking 5 seconds, boom, Dr. Phil's team is on it. And the entire video, if it's a 3-hour video and I show a 5-second clip, okay, of him, ineligible for monetization. And I'm like, okay. So either you cut it out, you cut that clip out, okay, or you allow them to take all the money, fine, it's their content, or you dispute it. I would never dispute it. I don't want to ever. So this is WFLA. I'm not afraid, because all credit to WFLA, okay? If they tell me to take this down, I'm going to take it down. That's how it works. That's how we roll, okay? I like the legal side of things. Thank you, Michelle. Yeah. Don't worry, I'm not snarking it at you. I'm just telling you what happened. Thank you for bringing it up. Wonder what the next huge case is going to be like this one. I know, right? Damn, this case was, my word, what a case. Okay, so it's very glitchy. I can't see what the heck is going on here. Let's just go forward a bit. Shame, the signal is bad. Okay, so let's take that off. Yes, Brad. Yes, very interesting. Sorry, Doug, I can't see anything. Ooh, here we go. Okay, what's going on here? Okay, so what's the time? I'm watching the time. So now at least you guys understand what happened. You cannot fight people. You can't use people's content and then say, but it's fair use. If they don't want you to use it, they will tell you. Even YouTube's bots will automatically pick it up. And that's that. So anyway, so here we are streaming, yes, WFLA. Shout out to WFLA. Thank you all the Grizzlies for being here. This is an odd time, right? To be live with you guys. 1:30 Florida time. It's matching my sleep schedule perfectly. Mine is all messed up as a YouTuber. All right. Thanks for listening. I really hope that this case goes to trial. Let's see what you guys voted. Okay, now we can see them walking there. Cool. What a shame that the Laundries are not there. What a shame. Oh my word. I just want to quickly see if you guys are answering any polls or anything like that. Let's put this on. Damn, last time I saw you in the snarky, witty mode. I'm scared right now. What do you mean? When? You mean now? When? Yeah, I'm talking every 7 seconds. And if they do copyright claim me, it's theirs. They can have it. It's okay. I would never say, no, it is mine. Did you guys wait? Oh, is the poll? I think the poll is like finished now. I had a poll up earlier. I think it's done. All right. You're like, Peter is so good looking and nice. Are we crushing on, like, you guys, are you crushing on JB or Peter right now? Okay, I know that's not the question, and we're not trying to make light of the situation. It's just like, yes, Amy, I see what you're saying. Thank you, Brad. Thank you for your $12 super sticker. I really appreciate it. Opposing lawyers seem pretty chummy. They always kind of do. I'm always amazed, you know? Lawyers are always very civil, of course. Well, they're supposed to be. Yeah, what the hell? Why aren't they there? The ever elusive Laundries. That's all we want to see. Oh, you saw me snarking it up on the Antidote channel. Okay, my bad. I don't know what I said, but yes, don't worry. Oh, what can we see here? Now, what's the time? We're still watching. 5 more minutes. 5 minutes. Okay, take a poll. Should I make another poll? I mean, I can. We've got the time, so let's see. Let us see what's going on here. Go to my channel. Gabby's parents look strong. They really do. I really, really hope that this will go to jury trial, right? I really hope this won't get dismissed. And do you think, do you guys think, hold on, sorry. I'm going to my poll now to see if it's still there. Now I can hear myself. Oh, the poll's there. Okay. Do you think the case will go to jury trial? 43% say yes, it will. So that was my question. 44% say yes, it will. 13% say no way, it will be dismissed. That's what I'm worried about. I'm really worried about it being dismissed. But do you think it'll be dismissed today, or is there like a delay? Because apparently it could take up to a week or 2 weeks, 2 weeks to actually decide. I'm thinking they're deciding today. Am I right? And then 42% said not sure. And 1% said what case? Damn, where have you been? WFLA. Waffling. No problem, doodle bug. I still think the Petitos' intention is to reveal Brian's guilt. Yeah, I'm thinking, you know how when Johnny Depp went to court, right? He went to trial. He didn't want to do that, but he's like, okay, I'm going because I want the truth to come out. That was his intention. It feels like this could be similar to that, where they just want the truth to come out, you know? Yeah, the decision in July, according to JB. Oh, man. That's the problem. So the hearing will be today, the decision in July. Okay. All right. So what have we got going on here? Yeah, now they're just showing, this footage is so sad to watch, right? Whew. Do you guys still sometimes go back and watch some of the footage or no? Ooh, okay, we're counting down. We're going to have the hearing. Claire, you're excused, but you better hurry back up. Oh, my word, that's so cool. Yes, you need to get a notebook. Yes, you do. Yeah, we still have the West brothers, Laurie Vallow, and Tristan Bailey's trials coming up, right? I was making an example, okay? I'm allowed to. I never covered the case. Have rewatched some of yours. Okay, cool. Doug is in the courtroom. That's awesome. Doug is in the courtroom. Okay, let's see what's going on here. Okay, JB's in studio. $4.99 super sticker. Thank you so much, Mareka, for your $4.99 super sticker. Really appreciate that. Thank you for supporting the channel. Oh, man, this must be so stressful. Let's find Doug. I just want to see what he's up to on my phone here. Doug from Northport. You can't watch the footage of Gabby? Oh, yeah. Sometimes I still watch it. It's just so... What a case. I can't. Yeah, it's difficult to watch. I understand. But sometimes I'm just like, wow. Like, I still cannot believe what happened to her. Wow, let's see Doug. So Doug's in court, but he's not streaming. I can't see him streaming. Yeah, please hit the like button, everyone. If you're rolling in now. I got all dressed up for court for you. If you like my court outfit, hit the like. I've also got some coffee, so let's have a sip of that. Okay, the hearing's going to happen in a minute here, so let's see what they say.
To perhaps provide a little bit more analysis, we've got Peter joining us from right here in the Tampa Bay area, joining us from Clearwater. Peter, nice. Again, a hello there to you. As we get underway, what's the most important thing for our viewers to know as this hearing gets underway in just a couple of moments?
Thank you, Brad, for your $2 super sticker.
To any analysis or breakdown about the motion to dismiss, about the complaint, about the response, about the reply. Yeah. There's not a lot of new information that comes out in these hearings. Sometimes the judge doesn't even ask for oral arguments. In a case like this, he's probably going to let the lawyers do their thing. They're going to repeat a lot of things that were in the motions, and then the judge will likely reserve ruling. He doesn't have to. Within his discretion, he can make a call right now and say granted or denied, with or without prejudice. He can make that call right now. But most people expect that he's going to reserve ruling, and then we'll find out later in a written order what his decision is and why his decision came down that way.
Okay, that's what we're waiting for. If some of you are like, why do you keep turning the sound off, or why do you keep talking over them? Here we go. It's because you guys are here for my commentary. That's why, okay? If you want to go watch it, please go watch it on WFLA.
Back here with you live, folks, after the hearing is concluded.
Yes. Let's see this hearing. Can you hear?
I am electronically present in the courtroom today as I'm abiding by the court's quarantine protocols. We have technology in place to allow the court's work to continue without delay.
Ooh.
My preparation for all hearings today, not simply these two cases, has been the same. The court is prepared. Whether you are joining us in person in the courtroom or via Zoom, welcome. There are two housekeeping items to address.
Ooh, housekeeping.
First, only credentialed media authorized by the court's public information officer, as well as the court reporter, may record these proceedings in the courtroom or on Zoom.
Okay.
If you have not received that authorization in advance, you may not record these proceedings. Second, we have two cases this afternoon. The first case we will address involves the parents as parties in the lawsuit. We will complete that hearing before moving on to the second case, which is the case involving the estates. So let's begin. The court's going to first call the case of Joseph Petito and Nicole Schmidt versus Christopher Laundrie and Roberta Laundrie, case number 2022 CA 1128. Ask the attorneys to please make their appearances and introduce their clients if they're present.
Good afternoon, Your Honor. Patrick Riley Ford, sitting to my right, Joseph Petito, and also sitting to my right, Nicole Schmidt.
Thank you. Mr. Luca?
Good afternoon, Your Honor. Matt Luca on behalf of the defendants, Christopher and Roberta Laundrie, who are not present.
Thank you very much. Now we are to hear the motion to dismiss filed by the Laundries, which is at document identification number, or DIN 33. The plaintiffs have filed a response, which is at DIN 38, and the defendants have filed a reply, which is at DIN 39. I've reviewed those filings as well as the other materials submitted by the parties. So, Mr. Luca, you have the floor, and if you'd like to go to the lectern, that would be great.
Yes, thank you, Your Honor.
I have to say, Your Honor, it's unusual to be staring at an empty spot up there at the bench.
Yeah, very unusual,
Well,
guys.
it is what it is.
What do they tell actors, Your Honor? Just find a place on the wall and stare at that? Well, thank you, Your Honor, for your time this afternoon. I appreciate it. Your Honor, I won't spend any time going through the general standard on a motion to dismiss. I know Your Honor is well aware of that, so I'll just jump right in. Your Honor, our position is straightforward. A cause of action for intentional infliction of emotional distress was not intended to include liability for a defendant who does nothing, who has no contact with the plaintiff. All of our arguments regarding outrageousness, legally permissible conduct, causation, and the presence of the plaintiff all go back to that premise.
Nice job.
And show why there is no legal footing for this cause of action in this context. Conduct that amounts to remaining silent and maintaining privacy is not intentional infliction of emotional distress. And there are no cases where such conduct was found to be intentional infliction of emotional distress. Rather, plaintiffs argue that the Laundries had an obligation, a duty to speak. The law imposes no such obligation to speak, and the state and federal constitutions support that. In our society, under our laws, people are free not to speak.
Hi, Bill.
Your Honor, the elements of the cause of action alleged are a deliberate or reckless infliction of mental suffering, outrageous conduct, the conduct caused the emotional distress, and the distress was severe. I'll first address the outrageous conduct element, Your Honor. So the standard for determining whether or not conduct is outrageous is that the behavior claimed to constitute the intentional infliction of emotional distress must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. That is conduct that is atrocious and utterly intolerable in a civilized society.
What do you guys think?
It is an objective standard, and the subjective response of the plaintiffs is not what controls. The issue of whether or not conduct is outrageous is a question of law and for the court to decide. And that standard is extremely high in Florida. It is not enough that the defendant acted with an intent which is tortious or even criminal, or that the defendant intended to inflict emotional distress, or even that the defendant's conduct can be characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. Now, Your Honor, looking at the amended complaint in this case, paragraph 32 provides a summary of what the plaintiffs alleged is the conduct that was outrageous. So they allege first, failing to advise the plaintiffs that Ms. Petito was deceased. Second, failing to disclose to the plaintiffs the location of Ms. Petito's body. Third, taking a family vacation with their son, Brian Laundrie, who they alleged had murdered Ms. Petito while the plaintiffs were looking for Ms. Petito.
Okay, thank you.
Fourth, blocking access to their cell phone and Facebook page to preclude the plaintiffs from contacting them and getting information regarding Ms. Petito. And finally, that the Laundrie's attorney, not the Laundries themselves, issued a statement to the press expressing hope that the search for Ms. Petito is successful and that Ms. Petito is reunited with her family.
Was
Is
that
there a
Doug?
distinction between the attorney doing it on behalf of the Laundries versus the Laundries?
Well, Your Honor, the attorney is obviously not a defendant in this case. And there are no allegations that within the complaint that the Laundries directed the attorney to make that statement, what information the attorney had with regard to making that statement. So I do believe that there is a distinction, Your Honor.
Thank you, Melissa
Isn't under
Pick.
Florida law, isn't the attorney the agent of the client?
I do agree with that, Your Honor.
Then why does it matter that the attorney and not the Laundries themselves made the statement?
Well, Your Honor,
Nice.
what we don't know, what is not alleged in the complaint is whether their attorney was making that statement on behalf of the Laundries or whether he was making that statement in his personal capacity.
Well,
Mhm.
on a motion to dismiss, how am I supposed to construe the well-pled allegations?
Your Honor, on a motion
Grizzly.
to dismiss, I would argue to the court that by not alleging in the complaint that the attorney was the agent of the plaintiff, or, I'm sorry, of the defendants for purposes of making
Ooh,
that
you're getting
statement,
nervous, guys.
that they have that the plaintiffs have not alleged sufficient conduct that would cause liability for the defendants for the statement by their attorney.
Well, assume for the sake of argument,
Yeah, it is,
the
it
court
is. Oh, cute.
concludes that there was sufficient allegations that the attorney is the agent for the Laundry. So assume that to be true.
Go, Judge,
Now
go.
we have a situation where the Laundries themselves are making a statement and not standing silent. So what does that do to your argument about staying silent?
Your Honor, I still don't I still don't think it necessarily makes a difference.
Yeah, we love the
I
judge.
mean, I understand what the court's saying, that that if we impute that statement to the defendants, that would not be complete silence by them. However, the defendants do have a constitutional right to have an attorney and to have that attorney speak.
Mhm.
So again, Your Honor, in my view, the attorney was merely exercising the constitutional rights of both the attorney and of his
What a bunch of
clients,
cowards.
by
Oh, my
making a
word.
statement.
Okay, but when you make an affirmative statement, that's the antithesis of staying silent, right?
I would agree with that, Your Honor. Yes.
You may continue.
Thank you. Your Honor, the plaintiff's claim of outrageous conduct in this context is novel. The plaintiffs have cited no cases where a person's silence except with regard to what Your Honor just raised with regard to their attorney's statement, was considered outrageous, regardless of the circumstances. And they certainly haven't cited any cases
I'll pause it for 2 seconds. Look at his body language now. He's extremely nervous.
where a statement by a person's attorney has been considered outrageous. All of the cases they've cited involve some action by the defendant.
Yeah, swaying.
Accepting the allegations of the amended complaint as true and allowing the case to proceed further would require any person and their family to speak about an alleged crime or other tragic event of which they may or may not possess knowledge. And that is simply not something that our legal system requires. For example, if a family member came to me and told me that they did something terrible, the plaintiffs want the law to impose an obligation on me to then report what that family member told me. And that just isn't the law. even if that I'm sorry, go
Let
ahead.
me
Your
make sure I understand what you're saying.
Yes,
Are you saying
brilliant.
that they came to you in your capacity as a lawyer or as just a normal person?
Just a normal person, Your Honor, just a family member.
Oh boy.
Well, does Florida recognize a privilege, a parent-child privilege?
Your Honor, I'm not arguing privilege. This could be somebody who is not a parent, a child, a wife, a husband, just anybody. My argument is not that there was a privilege between Brian Laundrie and his parents. My argument is that even if Brian Laundrie conveyed information to his parents, that they don't have a requirement then to speak with regard to that information. They don't have to share it.
Okay, well, let's go down that road for a moment.
Yes, let's go down that
This
road.
is where I'm having some difficulty.
Ms.
I
Swain.
fully understand and get the constitutional right to remain silent. That being said, we're on a motion to dismiss on a complaint where I have to assume the facts are true. And you're trying to get me to say that the complaint itself demonstrates the existence of right to remain silent. And I'm trying to understand how that is, or is that more of an affirmative defense that should be fleshed out in the pleadings?
Your Honor, I don't agree that it's an affirmative defense that needs to be fleshed out. I believe the court can, obviously the complaint alleges that the defendants were residents of the state of Florida, so the Constitution of Florida and the Constitution of the United States apply to them. And if you look at the complaint, Your Honor, even though it doesn't allege a formal criminal investigation, it doesn't use those magic words, so to speak, it does allege that Brian Laundrie murdered Miss Petito. It alleges that Brian Laundrie engaged in conduct to try to cover that up by sending text messages and things like that. It alleges that the defendants, his parents, the Laundries, were trying to help him escape the country. It alleges that the Laundrie family hired an attorney, and then once they hired the attorney, at that point, all the contact with the plaintiff stopped. And the only statement we have is that one statement by their attorney that the court referenced. So under those circumstances, as alleged in the complaint, Your Honor, that's enough for the court to say somebody in that situation could invoke their Fifth Amendment privilege. That's not something that the court would need to find additional facts. The court does not need to look outside the four corners of the complaint. There are sufficient allegations within the complaint that would trigger somebody in that situation exercising their Fifth Amendment privilege.
Damn. grill him some more. This is amazing to watch. Oh my word.
Your Honor, would you prefer for me to continue with the outrageous element or move on to the legally permissible element, since that seems to be
Whichever way you want to go.
Okay, thank you, Your Honor.
I'm not shy in asking questions.
I understand.
He's hardcore.
Your Honor, the plaintiff's cause of action could also extend to somebody who, may not be in the situation where they were told something, but maybe they witnessed something, or maybe they came upon some evidence, and somehow they had some information that might be relevant to some tragic event. The plaintiff's cause of action would impose an obligation on people like that to contact the families who may be involved in that situation and disclose what they knew, or they would fear being sued. The slippery slope of allowing this cause of action to proceed would really require anyone with knowledge of events that are hurtful or which cause emotional distress to another to convey their knowledge or potentially be exposed to liability. Now, the underlying crime.
But again, I go back to, there's an allegation that the Laundries made an affirmative statement and put out into the public various statements. So am I not supposed to consider
I love this judge. I love this judge.
Because that's a voluntary act by the Laundries.
I understand, Your Honor. And I assume you're referring to the one statement by the attorney alleged in the complaint. Assuming for the sake of argument that is an affirmative statement by the Laundries, Your Honor, you can definitely consider that. But again, in the context of the overall case, is that statement alone sufficient to meet the standard for outrageousness? If, let's say, for example, I had, some knowledge about a crime that somebody committed, and I made a public statement about some aspect of that case, but I didn't share everything that I knew, or I hedged my bet, so to speak. Would I then be subject to liability because I shared something, but I didn't share other things? That's really the question, Your Honor. Is what are we going to require of people in a situation like this? Are we going to require them to say everything that they know, or are they going to be allowed to speak freely or not speak at all? That's really the question before Your Honor.
Oh my word.
And Your Honor, I think it's important to keep in mind the standard that we're talking about here, that the conduct has to be atrocious.
I feel like this case is not very strong. It's Judge Hunter W. Caroll. Like, this guy is losing the battle big time, which is very encouraging for us to see, right?
And utterly intolerable in a civilized society. People who are faced with difficult challenges have to make difficult choices. In our society, which I would propose is civilized, recognizes at its core that things like remaining silent or speaking through an attorney are foundational rights. And those are choices that our society considers entirely tolerable. And in fact, they're codified in our founding documents. So, Your Honor, even considering the statement by the attorney, I would submit to Your Honor that's not atrocious. It's not intolerable in a civilized society for their attorney to make a statement for them like that.
Yes,
Your Honor,
Brad.
another thing I'd like to address that the plaintiffs raised in their response is that that the Laundries were somehow in an unequal position to the plaintiffs, and that made their conduct particularly outrageous. Your Honor, I don't think that the standard for unequal positions is really what the plaintiffs would qualify that under this circumstance. Your Honor, in Dependable Life Insurance Company versus Harris, which is a 5th DCA case from 1987, it's cited in our papers. Your Honor, in that case, and what the plaintiffs rely upon is Restatement of Torts, Section 46, subsection E, which states this unequal position argument. And what the restatement says is the extreme.
I'm just going to pause for a second, Shane. Like, Gabby's mom looks extremely distressed, right? This is very, very stressful. You can see it. Her dad, on the other hand, is like looking at this guy like, what the hell?
Extreme and outrageous character of the conduct may arise from an abuse by the actor of a position or a relation with another which gives him actual or apparent authority over the other or the power to affect his interests. Thus, an attempt to extort money by a threat of arrest may make the actor liable even where the arrest or the threat alone would not do so. In particular, police officers, school authorities, landlords, and collecting creditors have been held liable for extreme abuse of their position. Even in such cases, however, the annoyances that are not extreme, even in such cases, however, the actor has not been held liable for mere insults, indignities, or annoyances that are not extreme or outrageous.
Thank you, Louisa.
So, Your Honor, in Harris, what the court recognized there is that the result of this unequal position must be something that is akin to extortion, meaning that somebody threatens another person based upon their position to cause some harm. Like, I'm gonna cause you to lose your job. I'm gonna cause you to be arrested. I'm gonna hurt your family. Something like that. That's really what it's about. It's about somebody who has some authority to affect the person's life. It's not a situation where somebody might have information that another person doesn't have and they simply don't share it. That's not really what the Harris case or what the restatement are talking about when they say unequal positions.
Yeah, I really feel for them too.
Now, Your Honor, moving on to the assertion of illegal rights. The standard with regard to that element is that the conduct, although it would otherwise be extreme, such insistence is certain to cause emotional distress. Now, we have several rights at play here, Your Honor. You brought up one earlier, the Fifth Amendment right to remain silent. That is certainly one of them. There's also the First Amendment right of freedom of thought, which would include both the right to speak freely and the right to not speak at all. And that was cited in Woolley versus Maynard, a Supreme Court case from 1977. Again, it's in our papers.
Aren't we responsible for the words that we say when we say them?
I would agree with that, Your Honor. Certainly, if you say words.
I know. I
Johnny
can't
Depp
wait.
just got found civilly liable for defamation by what his attorney said.
That's right.
Right?
See, he brought up Johnny Depp.
Again, Your Honor, I understand that in certain contexts, the statements of an attorney could potentially be, lead to something like defamation. I agree with you on that. I think really what we're talking about here, though, Your Honor, is a statement by an attorney that even in and of itself is certainly not defamation, and it is not outrageous.
My understanding of the statement, and correct me if I'm wrong.
Yes, go judge.
The Laundries knew, and again, this is on a motion to dismiss, so I have to accept what is alleged as true. Not that it is true, but I have to accept it as true.
Mm-hmm.
That the Laundries knew where the Gabby's body was, and they put out a statement in the middle of the search.
Judge Hunter
hoping
W.
about
Caroll.
The success of that search, and then not either directing them or either staying silent. I mean, that's kind of my understanding of what is being alleged. Is that correct, or am I misunderstanding?
No, I believe that's my understanding as well, Your Honor, that the attorney made the statement while the search was ongoing.
And knowing exactly where the Gabby's body was.
Well, Your Honor, again, that's the rub, is the plaintiffs haven't alleged anything in the complaint as to what the attorney's knowledge was when he made that statement.
What a bunch of cowards.
that he had that information. That's a totally different thing. They've alleged that the parents, the defendants, had that information, but they don't allege that information was ever shared with the attorney, or that the attorney had that information when he made that statement. That's kind of the issue, is they haven't really made any allegations about the attorney and what he may or may not have known. It's really all about what the parents knew, and they don't make any allegations about what the parents communicated to the attorney. So really the attorney's statement, again, if just looking at it within the four corners of the complaint, there really isn't enough there to say that whether or not when the attorney made that statement, what his knowledge was about any of the facts of the case, frankly.
Sean, there were no-shows, absolute no-show cowards.
And I would also submit to you, Your Honor, that statement's fairly benign. I mean, I understand in the context that they've alleged, it could be construed as trying to divert attention or something like that. But again, it's a fairly benign statement. I mean, he's really just expressing that he hopes that she returns. And again, they haven't alleged what information he had when he made that statement.
Isn't the context really what's important here? And that's what the second DCA said in that insurance case where the adjuster denied coverage and did so knowing that the person didn't have long to live and just wanted to outlive the person.
That's true, Bill. That's true.
The second, which is binding on me, found that to be outrageous conduct.
That is true, though, Your Honor. In that case, the second DCA said that the actions of the insurance company in simply denying the claim, even though they had been ordered by a judge of compensation claims to pay the claim, that in and of itself would not have been outrageous. But what made it outrageous was that there was some sort of internal, decision made that they're just not going to pay it for a certain period of time in the hopes that the plaintiff would die. I agree with you that made that particular case, rise to the level of outrageousness. Your Honor, frankly, the statement by the attorney in this case doesn't come even close to that level of outrageousness. I mean, you're talking about, withholding medical care in the hopes that somebody dies so you don't have to pay for it. I mean, I don't think any of us sitting here would not find that to be outrageous. We're talking about a statement by an attorney sort of, boilerplate and generic, just expressing that he hopes that the search is successful and whatnot. I don't really equate those two. I mean, I do agree with your point, Your Honor, that the context is important. We do have to consider the context as alleged in the complaint in this situation. But I would just submit to Your Honor that even considering that context within the complaint, the attorney's statement is not outrageous.
Oh, no wonder where the Laundries are watching
About 5
from.
minutes left in your argument.
Okay, thank you,
They're
Your
probably
Honor.
watching
So,
WFLA.
I'll move forward, Your Honor. I know we filed a motion and Your Honor has read it, so I'm not going to try to belabor too many points here. But with regard to the assertion of legal rights, really, the plaintiffs recognize that the Laundries have constitutional rights, and that the conduct that they have alleged within the complaint is really an exercise of those rights. So what they argue in response is that the court on a motion to dismiss shouldn't consider certain things. Number one, because they allege that within the complaint, they haven't alleged state action. Number two, that they haven't alleged any constitutional rights within the complaint. And so the court shouldn't consider them. And then fourth, that the constitutional rights are affirmative defenses. Your Honor, with regard to the state action argument, as an initial matter, just because the government isn't trying to compel someone to do something doesn't mean constitutional rights don't go away. If you don't protect your own constitutional rights, even when the government's not trying to do something to you, then you would likely waive them. If the defendants in this case had made a bunch of statements, even if those statements weren't to law enforcement, those statements could absolutely be used against them. So, in that sense, Your Honor, those rights exist, irregardless of whether the state is involved. Your Honor, also, as a second point, there is state action involved here.
2 minutes, 2 minutes,
one
dude.
of the cases we cited to Your Honor in our motion sort of sums it up. It's Gerber versus Longboat Harbor North Condo. It's a Middle District of Florida case from 1991. And that court said, defendant's motion to dismiss is predicated upon its assertion that since it is not a governmental entity and has not assumed substantially all of the functions of a governmental entity, the provisions of the First Amendment as incorporated in the 14th Amendment simply do not apply. This court cannot agree with defendant's contention, and by applying the principles enumerated in Shelley versus Kramer, which is a Supreme Court case that sort of set forth that the third branch of government, the judicial branch, is also state action. This court found and continues to find that judicial enforcement of private agreements contained in a declaration of condominium constitutes state action and brings the heretofore private conduct within the scope of the 14th Amendment, through which the First Amendment guarantee of free speech is made applicable to the states. Now, obviously, we're not dealing with a contract here or a condo association or anything like that. But the point is the same, that when a party tries to use the courts to enforce something, then there is state action. And in this case, Your Honor, the plaintiffs want the court to enter a judgment against the defendants. They presumably will want the court to enforce that judgment. And they want to use the court's authority to compel the defendants to participate in the discovery process, all of which implicates their First Amendment, Fifth Amendment, all of their rights, Sixth Amendment right to counsel. So, Your Honor, in that regard, there is state action.
Yes,
I addressed the criminal investigation earlier, so I won't go through that again. Your Honor, with regard to the four corners of the complaint argument, like I said before, the Laundries are residents of Florida. It's alleged in the complaint. As such, the Constitution fully applies to them, and the court can consider those rights. The plaintiffs are essentially asking the court to force the defendants to go through discovery, pretrial proceedings, summary judgment, just to get to the point where the court finds that the defendants have constitutional rights. That's just a waste of judicial resources and the resources of the parties.
Hurry it up, dude. Close it.
With regard to the affirmative defense, nobody cited any cases where the legally permissible element is labeled an affirmative defense. I certainly haven't seen anything where it's the defendant's burden to prove that if there were to be a trial such that it would be an affirmative defense. Rather, the legally permissible element is really intertwined with the outrageous element. In the seminal case of Metropolitan Life versus McCarson, which is the Florida Supreme Court case that established the cause of action, the court explained how it applied in that case. And it said the facts as a matter of law are not so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. Rather, the insurance company, according to the terms of the policy, had the right to demand proof of ineligibility for Medicaid, or from Medicare. And then it goes on and it says, Metropolitan did no more than assert legal rights in a legally permissible way. As such, Metropolitan's actions are privileged under the circumstances. So, Your Honor, it's not really a defense. It's really part of the outrageous calculus, the outrageousness calculus, that the conduct isn't legally outrageous.
He's going overtime.
If there is a privilege or a legal right that's being asserted.
He's doing some
and Your
waffle.
Honor, we cite some additional cases in our reply that I'll rely upon in that regard. Your Honor also said that even if this is an affirmative defense, which I don't think it is, the court can consider an affirmative defense if it is apparent from the face of the complaint. Your Honor, we would argue that constitutional rights are apparent from the face of the complaint. They allege a crime was committed. They allege an attorney was hired. So it's not a situation where the court can't consider the defendant's constitutional rights. And in fact, in the case Huzzar versus Gross, which we cited in our papers, it's the first DCA case from 1985. It's a defamation case.
Hurry up, dude.
And in that case, the court was
said 5
considering a
minutes.
First Amendment privilege on a motion to dismiss and held that trial courts, upon motions to dismiss, routinely make decisions as to whether a privilege applies to protect an allegedly defamatory statement. So again, in that context, the court held that on a motion to dismiss, the court can consider a constitutional right of a defendant if that constitutional right is their defense.
Okay, well, let's just
Yes, please.
ask. I know you have identified what you contend is one crime, which is to actively assist Brian evade capture, essentially.
Yes.
Assuming, of course, that and not this is not within the four corners. I mean, we know outside of the four corners, but not in the four corners. Is there an allegation that there was an arrest warrant out for him? But assume, for the sake of argument, that is sufficient for purposes of us to find that there was some sort of active crime, if you will. Is there any other crime that the Laundries have been accused of or could potentially be accused of? Because before you can invoke a constitutional right to remain silent, there's got to be a crime, right?
Well, Your Honor, there doesn't necessarily have to be a crime. You just have to believe that you may be in jeopardy of a potential investigation.
Well, doesn't the case law talk about it has to be a chain in the causation towards a crime?
Get him.
Your Honor, I don't disagree with you on that point. What I'm saying, though, is there doesn't have to be a formal investigation. If I left this courtroom and committed a crime and nobody knew about it, I'm not obligated to go confess that crime. Like I can assert my silence for as long as I feel like I need to protect myself.
Okay.
Well, let me ask you this, because
Yes, Sean, I'm pumped.
I'm familiar with is in a deposition, the Fifth Amendment would have to be invoked as to each specific question. So, for instance, if the question is, what is your name? You might not have a Fifth Amendment right to not answer that, depending on the context of the alleged crime. So I get back to what is the crime here? And isn't that really something that we need more pleadings to be able to accurately identify so that I have a better standard as to whether or not your Fifth Amendment argument actually is applicable?
Oh boy.
I don't think so, Your Honor. I mean, certainly the plaintiffs have alleged criminal conduct, most of which by Brian Laundrie. I'll agree with that. But they do allege that the Laundries, potentially were trying to assist Brian Laundrie in leaving the country.
Allegedly.
Could be obstruction, could be something else. There could be, again, we're not leaving the complaint when we talk about that. And so in that regard, the defendants still wouldn't have an obligation to speak about other things that may be sort of tangentially related to the whole situation. If there is
they went
potentially
camping.
crime involved. I mean, Your Honor, in Miranda versus Arizona,
Oh man.
the Supreme Court held the privilege is fulfilled only when the person is guaranteed the right to remain silent unless he chooses to speak in unfettered exercise of his own free will. So it's the defendant's exercise. It's not something where, the defendant can maintain his silence only with regard to certain things. If he's not being compelled to answer questions, he doesn't have to speak, period, at all. Again, from Miranda versus Arizona, the privilege has come rightfully to be recognized in part as an individual's substantive right, a right to a private enclave where he may lead a private life. That right is the hallmark of our democracy.
Yeah, he is.
So again, Your Honor, it's not, in Miranda versus Arizona, the court wasn't parsing what questions a defendant can or cannot answer. They said the right is a private enclave where a person can lead a private life. They can maintain that privacy for as long as they're able. Now, of course, there are certain situations if defendant is subpoenaed to testify, perhaps certain questions could be parsed, like what the person's name is or something, as long as that's not incriminating, which in some contexts it is. This is again, going to the plaintiff's argument, they haven't alleged that anybody was compelling anybody to do something and they refused or something like that. In that context, everybody has the right to their private enclave. They don't have to come and affirmatively state everything they know about everything. That's just not the way our society works.
Yeah, she's also there.
It's not how the Constitution works. People are protected until they're not. And so that,
what an argument,
Your Honor. I don't believe that the Laundries would have an obligation to provide certain information and not provide other information. That they can withhold all information until it's compelled of them.
Horrible.
That's or they're provided immunity by the government or whatever the circumstance might be.
Gross.
Well, let's put a pin in that right now, so I
Put
can
a pin
hear
in
from
it.
your opponent.
Yes, Your Honor.
Yes, opponent
And, Your
time.
Honor, for our remaining arguments, we'll just rely upon our papers unless the court has some specific questions that you'd like to address.
Thank you, sir.
Okay. Ooh. Okay.
May it please the court.
Yes.
Your Honor, this case is not simply about the silence of Christopher and Roberta Laundrie, who knew that their son had brutally murdered Gabby Petito. It's not simply about their callous refusal, despite pleas from the Petito family, to speak up about whether or not Gabby was alive and if she wasn't, where her body was located. It's about a course of conduct that they committed from the moment they learned on August 28th of 2021 that their son had brutally murdered Gabby Petito up until the time that her body was found. And as this court has already noted and pointed out, that includes the statement that was made the one time they decided to speak up. They spoke up through their attorney, and I'll touch upon the importance of that in a little bit.
Go get him, Tiger.
As the court knows, you're bound to accept as true all of the facts alleged in the four corners of the complaint. And I'd just like to review what some of those allegations are.
Well, let me ask you this, Mr. Riley. And let's lay aside the statement that the attorney made on behalf of the Laundries. What duty did the Laundries have to do anything to help Mr. Petito and Ms. Schmidt?
That's a fair question, Your Honor, and I've struggled with the answer to that particular question. And I guess maybe by answering this, I'm deflecting, but my answer is this. It's about what they did with the information that they have, not just not disclosing what they knew to the Laundries. And by the way, they could have, to the Petito family, excuse me, they could have made an anonymous phone call and said where the body was located, and that would have helped this situation tremendously. They knew starting on August 28th of 2021 that Gabby was dead. They knew where Gabby's body was. They knew that the Petito family was desperately searching for information.
How do they know that they know?
Affirmatively. They didn't just remain silent. Brian Laundrie came home in Gabby Petito's van by himself to his family's home. That family, knowing that Gabby was dead, knowing their son had murdered her, knowing where the body was, and in particular, knowing that Joseph Petito and Nicole Schmidt were desperate to learn where their daughter was located, they went on vacation.
There it is.
They assumed and continued their normal life as though nothing had happened, while this family was suffering, wanting to know what where their daughter was. Not only did she not.
Let's get back though to legal duty. I hear what you're saying, that these facts might sound bad, but we're not talking about social mores here. We're talking about legal duty.
We're talking.
That's the problem. Yeah.
Let's try to focus in on what duty did the Laundries have? What did they owe to?
That's the
Gabby's
problem.
parents?
Well, let's put in perspective what the relationship was, Your Honor. These people were not strangers. These people were. Their son was engaged to marry Gabby Petito. Gabby had lived with them for about a year. They had both visited Joseph Petito's home and Nicole Schmidt's home. They were cordial. They had a cordial relationship, a warm and friendly relationship. They knew how much Gabby meant to Joe and to Nicole. Going to the issue of a duty, Your Honor, I struggle with that. I admittedly, it's difficult to say what it is. And that's why I'm saying there was a course of conduct that they did that was outrageous, culminating, in my view, in the statement that was made by their attorney, who, as Your Honor pointed out, is their agent. And what that attorney said in particular is telling. So there's no question that he represented, that he was making that statement on behalf of the Laundries, because he says, it is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming on behalf of the Laundrie family. It is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. That statement was issued with the full knowledge and consent of the Laundries, with the full knowledge on the part of the Laundries that Gabby was not alive, and that Gabby's body was located somewhere out west. And instead, they make a statement saying, we hope you find her. We hope you're reunited, giving them false hope that perhaps their daughter is still alive. If that's not outrageous, Your Honor, I don't know what is outrageous. So
the problem is, sorry to pause, I'm going to carry on now. It's just that it's about, ethics, moral compass. They don't have any, obviously, the Laundries clearly. But this is the problem. This is why I'm worried. And you guys?
I think when you talk about their affirmative duty to speak up, I struggle with that.
But
they did speak up. And when they spoke up, they made that very callous, that very terrible statement, giving hope to Joe and Nicole that perhaps Gabby was still alive, with full knowledge that she was not. And Judge, when I talk about the course of conduct, I want to talk about some of the cases that I cited in my response to the motion, where the court found that there was outrageous conduct. And I don't see how any of these cases are by any stretch of the imagination, worse than what happened in this particular case. In the McAlpin versus Sokolay case, a patient went to a hospital to have an x-ray done. She put on a hospital gown. She walked into the x-ray room, and the minute she walked into the room, the doctor began berating her in front of other staff.
That's
because
Rose,
she
everyone.
hadn't paid another doctor's bill. He told her he wasn't going to treat her, and he told her that he was going to call security and have her removed from the hospital. That, according to the court, was outrageous. In Nims versus Harrison, a teacher, two students of a teacher wrote, published, and circulated a newsletter in which they had an article called Low Life, and they referred to that teacher in offensive language, threatened to kill her, threatened to rape her children, and threatened to rape their cousins. Outrageous. Ford Motor Credit Company versus Sheehan. Collection agent is unable to locate the debtor, contacts the debtor's mother, tells the debtor's mother that she's from a hospital out in California. She's trying to locate the debtor because two of the debtor's children have been in a serious car accident, and she wants to find the debtor so that she can let him know about this accident. The son speaks to the mother later that day, hears the story from the mother, spends the next 7 hours calling hospitals and police departments out in California, only to find out that this story was false. That was outrageous. The Dependable Life Insurance Company versus Harris case was talked about previously. In Liberty Mutual versus Stedman, the company delayed authorizing a lung transplant, even though a judge of compensation claims had already ordered that they pay for the lung transplant. The carrier knew she would die without the lung transplant, so hoping the problem would go away, they denied payment in an effort to intentionally induce stress on her part to speed up her demise. The court said, under the totality of the circumstances, it's outrageous. Williams versus Mineola, and it's these two last cases that I'm going to cite the court to that I think are most instructive here. In Williams versus Mineola, police officers attended the autopsy of a teenage boy who had been murdered or committed suicide, and they were there with a videotape, a video camera, and a camera to record it because of the suspicion that a crime may have been committed. They took that video, they took those photos, and they took them to a party. And at the party, they shared them with other persons, including other police officers from surrounding jurisdictions.
Good
and they
examples.
laughed and they joked about what was in those photographs.
It's quite
The
slick.
court found that to be outrageous, and here's what the court said.
Say it, say it.
As for what is outrageous or reckless or what is not, we emphasize that our society, as reflected, for example, in decisions of the courts of Florida cited earlier in this opinion, shows a particular solicitude for the emotional vulnerability of survivors regarding improper behavior toward the dead body of a loved one, and the special deference paid by courts to families' feelings where rights involving dead bodies are concerned is central to our decision. This area is unique, and once it has entered behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable.
Stand by, everyone. Hello to Mike. Nice to see you here. The Laundries didn't show up for anyone that's rolling in now. And Rose is sitting in the back as well. And of course, there's Bullhorn Betty as well. Doug from Northport, Florida is also there. And if you don't know any of these names, please catch up on the playlist after this. Then you'll know everything, okay?
One obvious reason is that the bereaved are already suffering psychic trauma because of the loss of the loved one, and are especially sensitized to any disrespect or indignity directed at the deceased body or a representation of it. The potential for severe emotional distress is enormously increased in that situation. All of this is well known to the ordinary person, and so a level of carelessness or callousness which might not be considered tortious in other situations can show outrageousness and recklessness when a dead body or a picture of a dead body is involved.
Well, Mr. Riley, how is a statement, we hope this search is successful, how is that in itself outrageous?
It's a lie. It's said with knowledge that there's no hope of finding her alive because she's dead. It's said with an intention to give false hope to a family that their daughter may be alive. That's outrageous. This is, and at this particular point in time, they had.
Sorry for pausing. I hope that the statement comes across, because it might also be legal to say we hope that she's reunited with her family. That could mean that her body is reunited with her family. You know what I mean?
Had been begging the Laundries to tell them where their daughter was, and this is the statement that they issued. The one time they chose to speak up, this was the statement that they issued. A lie that gave false hope to Gabby's parents that perhaps she might be alive. The other case, Your Honor, that I think is instructive is the Thomas versus Hospital Board of Directors case, and I think this one may be even more instructive. In that case, during I believe it was a hip transplant surgery, the decedent died. She died of cardiac arrest. What she really died, the real reason she died of cardiac arrest is because she was given an overdose of a particular medication during the surgery. And the doctors and the nurses agreed that they would not report the true reason for why she died. They would say that it resulted from complications of surgery.
No one knows.
As a result, the complete autopsy was not done. The body was released to the family, and less than a week later, as the decedent's daughter was trying to bury her mother, she received a telephone call from the medical examiner saying, you need to bring that body back immediately. We have to perform a complete autopsy. Again, the court said that was outrageous. And what the court said was, We believe that the appellee's conduct in making false statements, and isn't that what Mr. Bertolino did on behalf of the Laundries here? We
Whoa.
believe that the appellee's conduct in making false statements which led to the interruption of Mildred Thomas's funeral and the return of her body for a second, more thorough autopsy rises to the level of atrocious and utterly intolerable behavior which cannot be condoned in a civilized society. As noted in Stedman, when an actor has knowledge that the other person is peculiarly susceptible to emotional distress, and the Laundries knew that because this family publicly said they were distressed trying to find their daughter, the actor's conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge. We believe that in a situation where a person's loved one has died, it would be apparent to anyone that the person would be susceptible to emotional distress, and therefore that the action of providing false information concerning the loved one's cause of death meets the standard for a claim of outrage. In this case, they provided false information, a false impression, knowing that Gabby was dead, that she was still alive and she could be found by the family if they were searching in the right place.
Oh boy.
So I also think under the restatement,
Yes, it speaks volumes.
Restatement of Tort Section 46, comment F says, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the action proceeds in the face of such knowledge, where it would not be so if he did not know. And that's basically what the Williams court was saying, and that's what I'm saying in this instance. The Laundries knew of the fragile emotional state of Joseph Petito and Nicole Schmidt at the time that that statement was issued. They knew that she was not alive. They knew that the family was hoping to find her, and they put out a statement as though they were supporting them, saying, we know she was our son's fiance. And we hope that you find that body too, or you find her and the family is reunited, excuse me. That's callous. That's callous, it's shameful, and it's outrageous. And by the way, the only reason that Mr. Bertolino is not a defendant in this action is because he's not a citizen of the state of Florida.
Imagine if he was there. Oh my word.
I think there's also support for our position
I also think so. Denise?
under comment E to the restatement, which says unequal position of the parties in a relationship where one asserts and has the powers to affect the interest of the other may also supply the heightened degree of outrageousness required for a claim of intentional infliction of emotional distress. Here, the defendants clearly had the power to affect the interests of the plaintiff because they could have told them where her body was located, and they chose not to do so. Your Honor, I don't think there's any question. There's been nothing raised, at least by counsel in his argument, that the conduct didn't cause severe emotional distress to my clients. To the extent that they would suggest and have suggested, well, they were already distressed anyway. So all we did was increase their harm. I guess it's okay to kick someone when they're down, according to the Laundries. But going back to those two cases that I cited earlier involving dead bodies, the parties were already grieving, and it was the conduct after death that the court found was outrageous and permitted the case to move forward. So I think we have the issue of their conduct was
I'm well aware,
intended to harm,
Troy.
or certainly what they did, they should have known was likely to cause severe emotional distress to my clients. We clearly have an outrageous conduct on their part. I think we have established that the conduct caused more emotional distress. It doesn't have to be the only cause of their distress. If it increases, that's sufficient to recover. And I don't think they're contesting at all that the emotional distress was severe. So I'll move on to the suggestion that the defendants get to raise affirmative defenses at this point in time.
Well, and
Me too.
Thank you for doing that, because my question there is, I mean, the rule is that I can address it if it is apparent within the four corners. And effectively, you alleged conduct which arguably could be considered criminal on behalf of the defendants. So why can't I consider the Laundrie's constitutional right to remain silent and other constitutional rights within the context of ruling on this motion to dismiss?
Well, Judge, I'm curious to find out what conduct it is
Yes.
that the complaint says the Laundries committed that was potentially criminal. So if the answer is they were harboring a fugitive, there were no charge. Again, we're outside the record, but to my knowledge, or outside the four corners of the complaint, but the complaint doesn't allege that there were any charges pending against Brian Laundrie at the time. So they couldn't have been harboring a fugitive. Are they?
I'm not sure the absence of charges is the criteria that we use.
Well, Judge, what this is forcing me to do to address that is to go outside the record, which is not what we're supposed to do, to say he wasn't running. According to everything we know, the police knew where he was. So he wasn't a fugitive, so they weren't harboring a fugitive.
Okay.
I don't know what were the accessories after the fact. I don't know. Is there something they want to confess to? I'm happy to hear it, but I don't know that anywhere within the four corners of the complaint there's a suggestion that the Laundries were under investigation for a crime or that they had committed a crime. So first of all, I think we shouldn't even be considering this as an affirmative defense. Secondly,
I'm also
you can't
scared.
look at the complaint and determine, was there an investigation into them and what were the crimes? So I don't think the Fifth Amendment applies. If we turn to the First Amendment, I will tell you I strongly disagree with counsel's assertion that it applies in all instances. The defendants rely on Woolley versus Maynard for the proposition that they have a constitutional right to say nothing. But Woolley says that the right of freedom of thought protected by the First Amendment against state action includes both the right to speak freely and the right to refrain from speaking at all. And we're not talking about state action in this case. The defendant says we're asking the court to force the defendants essentially to say something. That's not what we're doing. We're seeking damages for their conduct. More importantly, the First Amendment does.
Mr. Riley, though, I want to direct you back to paragraph 30 of your complaint, where you say that the defendants were keeping the whereabouts of Brian Laundrie secret, and it is believed we're making arrangements for him to leave the country.
Okay.
So that's something that the plaintiffs themselves injected into the case. So that's the basis of my question is, now that you've put that fact into the four corners of the complaint, isn't that the basis for me to consider, without having to need a affirmative defense filed, if you will, the constitutional rights of the Laundries?
Judge, what's the crime committed there? What's the crime that if they are making efforts to try to remove him from the country? He's not been charged with anything. He's not a fugitive.
That's true. That's true.
There's not, that itself does not suggest that they were committing a crime. There has to be an underlying basis.
He's good. This guy's very good.
If the complaint said there was a warrant out for Brian Laundrie's arrest and the Laundries were moving money around to try to move him out of the country, I agree with you wholeheartedly that you could arguably consider a Fifth Amendment argument in this case. But there's nothing in there to indicate that there was any criminal conduct on the part of the defendant. There's a statement that says they were moving money around to try to get him out of the country. Is that unlawful as it's pled in this complaint? No. It's not.
Caroline.
Going back to the First
zero way.
Amendment
This is not
issue, Your
dismissed.
Honor, it doesn't set forth an all-encompassing right to remain silent. Only where through state action they are being asked to espouse a religious, political, or ideological cause which they do not support do they have that right. And I will cite to you from one of the cases in my brief, my motion, the Overbay case, which says, freedom of speech includes both the right to speak freely and the right to refrain from speaking at all. At its heart, the right to refrain from speaking is concern for preventing government from compelling individuals to mouth support for views they find objectionable, or mandating speech that a speaker would not otherwise make. In other words, the court continued, the right to refrain from speaking limits the government's ability to sanction or override a private individual's preference for not making certain speech. Not all speech,
Grizzly.
certain speech. So let's look at Overbay.
Mr. Riley, you have 5 minutes left, sir.
Thank you, Your Honor.
Okay.
Are the Laundries suggesting that we're seeking to compel them to mouth support for a view they find objectionable? Do they find it objectionable to tell a grieving family where their daughter's body is located and that that she's no longer alive? Do they find it? Do they believe that they would have a personal individual preference for not making a statement that they knew where the body was located? That's ludicrous. The First Amendment does not apply in this particular circumstance. We pointed out that they contacted counsel to show a course of conduct and to support our proposition that they knew that Gabby was dead and that they knew where her body was located as of August 28th. They immediately contacted an attorney.
I get back to where is the duty, and certainly there's no legal prohibition on calling a lawyer.
I'm not, Judge, I'm not going there. I'm not I'm saying that's support for our position that they knew. That's circumstantial evidence, in my view, that's why it's in the complaint, goes to show that at that point in time they knew. I'm not being critical of them retaining an attorney. I'm not suggesting they shouldn't have. I like the fact that they retained Attorney Bertolini, and Attorney Bertolini said what he said on September 14th of 2021. So we're not saying they shouldn't have hired an attorney. We're not saying hold it against them for hiring an attorney. I'm simply saying they hired one immediately after getting a phone call from their son, who then returned home without Gabby. Circumstantial evidence to show that they knew. That's the only reason that I raised that issue about them hiring a lawyer. Your Honor, unless you have any other questions, I believe I've covered everything I wanted to cover.
Hey, look, he doesn't go overtime. Very good.
Thank you.
Mr. Luca, I'll give you 2 minutes for any brief reply, but let's keep it to 2 minutes.
Yes, thank you, Your Honor. Your Honor, one thing I would point you to with regard to that City of Mineola case, Your Honor, there is a second DCA case, Crenshaw versus Sarasota County Public Hospital Board. I think it's cited in both my motion and the plaintiff's brief. And in that case, Your Honor, that case also involved a dead body, a stillborn child. And basically what happened is after the child was born, deceased, somebody within the hospital mutilated the child. It ended up going down a laundry chute. And in that case, Your Honor, importantly, the court noted that obviously if the mother had witnessed all of those terrible things that happened to the child, that might be one thing. But the court noted that the physically injured party should be directly involved in the event causing the original injury.
We're going to discuss this all after, okay? So hang in there.
Hears it or arrives on the scene while the injured party is still there, then that person is likely involved. And then they go on to say, here, appellant did not allege that she saw the mutilated body or that she was involved in the event, except for the birth of the stillborn child in any way. So, and Your Honor, that Stedman case was cited in Mineola, and in Mineola, the fifth DCA said that to the extent that Stedman conflicts, they're not going to follow Stedman. But Stedman would control here because it is a second DCA case. And lastly, Your Honor.
We did a little skip.
I didn't raise this, get time to raise this initially, but I would point Your Honor to another important case, which is MM versus MPS. It's a third DCA case from 1989, again cited in the papers. And although not perfectly analogous, that
in
case
July,
is
apparently.
instructive.
July.
Because it involves the parents suing the defendant for something that was done to their daughter. And in that case, the defendant told the parents that he had sexually abused their daughter, but obviously the parents were not present for the abuse. In that case, the court found that the appellants were not present when the alleged mistreatment of their daughter took place and may not claim emotional distress for her injurious or offensive treatment. Now, the plaintiffs countered that the disclosure of the treatment of their daughter was what caused their emotional distress. And the court said, after reviewing the law, we are unable to conclude that learning the awful truth from the defendant afforded appellants grounds for recovery for their own distress. And the court said, if courts were to allow relatives of tort victims compensation for the distress they suffer when they receive bad news about family members, when there is no attendant intentional or reckless conduct directed toward them, an avalanche of litigation.
He goes overtime all the time.
Compensation is available for actual harm to the victim. Only in carefully prescribed circumstances is compensation permitted for relatives who suffer emotional distress. It is not lack of compassion, but necessity that restricts relief to the immediate victim.
Exactly true.
And Your Honor, in this case, I would just submit to Your Honor that allowing a cause of action like this to proceed would create an avalanche of litigation that the tort was never intended to cover.
Unfortunately, it probably would. Yeah, probably would.
Thank you both for your arguments. I will do my best to get a written order out within 2 weeks of today. Anything else in this first case before we recess the first case?
No, Your Honor. No, thank you, Your Honor. May I be excused?
Oh, my
yes, sir.
word.
I don't represent any parties in the second case, so.
That's fine. While Mr. Luca is cleaning up, is there anybody that's going to be here?
It'll take some time.
Case, which is Nicole Schmidt as administrator of the estate of Gabrielle Verona Petito versus Barry F. Spivey as curator of the estate of Brian Laundrie, case number 2022 CA 2115 SC.
That is Gabby's friend, Rose.
Patrick
Yes.
Riley on behalf of Nicole Schmidt as personal representative of the estate of Gabrielle Petito.
And has anyone appeared for the respondent?
Thank you, Mr.
No
E.
one, to my knowledge, has appeared. As Your Honor knows, Attorney Spivey, there was an order entered at the request of Attorney Spivey that because it was the Laundrie family who filed the objection to the claim that was made against Brian Laundrie's estate, they should defend the action. An order was entered appointing them ad litem to defend the action. It's been more than 20 days since I served the complaint on Mr. Spivey, but out of an abundance of caution, I'm giving the Laundries a period of time to respond, although the information that I have is that they are not going to and that a default will be entered.
I don't know about the second one either.
Well, Deputy Velez, if you could sound the halls for Barry Spivey as curator.
Interesting. Spivey sounds like a series of unfortunate events for them. And out goes the lawyer. No Laundries in sight. They didn't come today. So what I'm going to do is just mute this for a second. Okay, we're going to just mute it for a second and do it like this. So what I wanted to say is I'm fully aware that saying this is outrageous and all this, it's going to be a difficult one to not dismiss. But nevertheless, we're all here because we want justice for Gabby. So we're hopeful, but at the same time, realistically, it's a very difficult case to actually go forward to jury trial. Especially, I thought they had more solid evidence, about how the Laundries knew where Gabby's body was. But from what I'm understanding from everything I just heard, the only way they know that they knew is because of the call that the Laundries made on the 28th, and then Brian Laundrie driving home with Gabby's van. That's how they know. I thought they knew more based on like texts, or that they have actual evidence from the FBI that Brian told his parents. You know what I mean? And I understand that he obviously did, because then they immediately got a lawyer on the same day that he called. So, you know what I mean? But this is all very, very difficult to like prove in court. So let's have a look at this. What's happening here in the second one?
Well, I mean, Hopefully,
I think it will be dismissed
in the
too.
future, you can bring your trial calendar.
I apologize.
Okay. Well, we'll wait and see whether you obtain a default or if someone appears. Obviously, if someone appears, I want you all to go ahead and do the case management order and get deadlines set. And so that we'll get the case rolling. If you end up having a default, then we can set a trial. I don't think we necessarily need another case management.
Mike, I think it's based on the day that the Laundries then contacted Stephen Bertolino and then offered him a retainer to help them out and give them advice and all that kind of stuff. So I think that's how they know. But it just feels like very connecting a lot of dots that's going to be very hard to prove in court, you know?
There's no default.
True. Okay.
But the reality is, because you requested a jury trial, we're going to have to impanel a jury on it, assuming that you're going to proceed with the case. I mean, obviously, if you decide not to proceed with the case, then you don't need to have it. But we'll call a jury, and we'll go with
It's
that.
a chandelier.
Go from there.
Very well.
It's just, I'm trying to figure out, with all the other trials going on here and which judges are going to be here when, just need to start planning these things out.
I hope that doesn't mean what I think it means, but for next year.
Oh, I have no idea which judge is going to be here in 2023. That's the chief judge's prerogative.
Understood.
You guys are very sweet.
So I will not reset a case management if Mr. Spivey or an administrator shows up. I'd ask that you go ahead and do a case management order and send it in, a report. If it is a default, send my judicial assistant word that the default has been entered, and
does anyone know who this lady is
on
here?
our trial calendar where you're looking for.
Is this Gabby's
trial
brother?
to
I
be
think.
Had, and then we'll go from there.
Who's this
If-
lady here?
Assuming that
Here's Rose.
that there is a default, how many days of trial are you anticipating?
1 to 2 at the most. The witness list will be short.
I suspect jury selection will take us a little bit of time.
Well,
Yeah.
that's why I was saying 1 to 2, because I think I could try the case in a day.
Okay. Anything else in the second case, Mr. Riley,
No, Your Honor, thank you.
No? Okay. With that, we're going to be adjourned for the afternoon. Thank you all very much for being here, and have a good afternoon.
Thank you.
They
Your
look
Honor.
devastated.
You as well.
He's very classy. I really like that lawyer a lot. Keeps it classy, doesn't go overtime.
Breaking news on WFLA now.
Oh, damn, JB. Okay, thank you. That we could see that as well. Let's put it back on screen like this. We could see them all leaving. Okay. I'm just putting it on mute for now because I want to see them all like leaving the room. I didn't know they're still going to show this now. So what are we all thinking? Now, I don't even have to apologize for this because I never said I was a lawyer. Sorry that I'm not a lawyer, everyone. I'm not a lawyer, okay? I'm just a YouTuber, and I'm just interested in this case. And of course, we all want justice for Gabby Petito. And I feel like this attempt to go to jury trial is how I'm going to word it very carefully. This is about justice for Gabby. It's her family fighting for her. And you can see to this day, it's clear as day that the Laundries are just not, they're not even there. So it kind of already, puts in perspective the type of people that we're dealing with on both sides, right? So it could just be, I mean, of course they want to go to jury trial, of course. But I'm feeling like the Petitos are hopeful that this will just bring out the truth and really show the world the Laundries for what they are, right? I know there's some people in here that are on the Laundry side. I'm not one of those people. Damn, look at that. It was like one of those old school screens. Okay, so I'm going to remove this for now. justice for Gabby Petito, of course. So, I mean, of course, we all hope they win. But if I think of it from a legal standpoint, it's almost impossible unless they have solid proof. I mean, it's actually very difficult. Yeah, the second one wasn't dismissed. No one showed for the second. Interesting. Tons of lawyers say this will be dismissed and not go any further. I understand completely why they say that. Because this is like an emotional thing now, right? It's not legal. And that's obviously the problem. Of course, we all hope and we want justice for Gabby, but I don't know. I don't know what one can do about that problem. Like if a killer, if an alleged killer, because the FBI didn't say Brian murdered Gabby. They said Brian took responsibility, or he took accountability for Gabby's death. That's how they worded it. I still find that very interesting. Yeah, I didn't realize it looks like I have a crown. Okay, but so I'm gonna have one for today, guys. It's actually just a chandelier because I wanted to be like sort of in court. I don't know. I like the background. So the thing is, if there is a horrible alleged killer and then they take their own life, that in itself is kind of justice. I know it doesn't feel like it, but they don't get to live life anymore. You know what I mean? So they took control of it. That's kind of what none of us like, right? We don't like that happened, that he's now gone, he didn't get caught, he's not being held accountable. How awesome would it have been to actually see that go to trial? To see Brian Laundrie go to trial would have been like, whoa. But yeah, he didn't. He's gone. I know some people in here also still think he's alive. I'm aware there's a percentage in all of this, right? So if you haven't voted yet on the poll, please do vote. Is this lawyer talking now? Hold on.
Nicole Schmidt, we just want to express our thank you to Judge Caroll
I'll be back.
for the time he gave us today on the motion. We appreciate the time it's going to take him to make his decision, and we have no doubt that he will make the correct decision. The family will not be taking any questions, but I'll do my best to answer a few questions if you'd like.
How do you think the
He's so classy.
I was very satisfied and pleased with the question the judge asked, in particular about the statement that Mr. Bertolino made on behalf of the Laundrie family, because that says a lot. The fact that they knew she was deceased, they knew where her body was located, and they had the audacity to express a hope that she would be reunited with her family.
We'll listen to more of it now. They didn't say confess, they said took accountability for, which is I suppose the same as saying confess, but I find the wording quite interesting nonetheless.
How is the family holding up through all this?
As best I can tell, they're handling it as best they can. If you saw, there were some tears earlier today when we came in here, and I expect there will likely be some more tears.
I know that the family isn't taking anything, but I noticed Nicole was holding on to her necklace. Are you able to share if there's a meaning behind it?
It's Gabby's ashes.
Oh my word, you guys were right. It's actually Gabby's ashes. I just got goosebumps.
I'm sorry.
Wow.
Oh, it's a mass card. It's a drawing or a piece of art that someone from Australia, I believe, created utilizing a picture of Gabby.
It's from the foundation
and
picture
on the back
there.
of it is a prayer that Jim wrote.
Aww.
The defense alleged that they had a Fifth Amendment right, even though there was no criminal allegations. How do you feel about that? I heard you arguing about that in the motion.
True. There is no justice.
There has to be an investigation or a crime before the Fifth Amendment right applies. I don't know, and I'm waiting for the day for the Laundries to tell us what crimes they committed. Hopefully they'll do that someday, but I don't know what crimes they are asserting were committed. We did allege that they were trying to move some money around to get Brian out of the country, but there was no arrest warrant out for Brian. He wasn't a fugitive. From a criminal law perspective, I don't think that there was anything inappropriate about what they were doing at that point.
Was it upsetting not to see the Laundrie family present today?
I think for the Petito family, it was a relief. But I would like to have had them be in the courtroom and face the people that they caused harm to.
How confident are you this will go in your favor?
Well, as I said, I like the questions the judge was asking opposing counsel about the statement that Mr. Bertolino made. If someone doesn't find his statements, knowing all the facts that were known to the Laundries at that time. If somebody doesn't find that offensive and outrageous, I don't know what's outrageous.
Did you read anything into the judge saying only 2 weeks to give a decision?
No, judges typically take cases under advisement when there's a lot of research and a lot of cases cited, and so I'm not surprised by that at all. I'm surprised it's only 2 weeks.
That's true, Anna.
All right, thank you, everyone.
All right. And off they go. Off they go. Don't worry, Pamela. At least you're
Attorney
here.
Pat Riley speaking outside the courthouse in Venice, Florida.
Yes.
As we watch Gabby Petito's parents and step-parents walking away, hopeful that the decision that is returned in 2
Oh, man. Hopeful. Optimistic. But, oh, man. I don't know, man. I don't know. So that was, yeah, that was quite hectic. I don't know what else to say. I'm just like, that was, I didn't know what to expect from today. Like, what are we actually going to see? But we actually saw a lot, except the Laundries, of course. Man, imagine if they would have been there. Thank you, Michelle. Thank you. And yes, please go and watch it also on WFLA, of course. I was streaming it to give commentary to you guys, which, no, I didn't talk every 7 seconds. So if WFLA copyright claims they can have any money generated from the stream, which will be limited either way, it'll be very, very little. Don't you worry. People worry so much. I saw in that Depp and Amber Heard trial, they worry so much about how much money YouTubers are making. But like, don't worry. It's not a lot. Thank you for being here. That's mostly, I knew we were all going to watch it. I would be watching it too. And it's just so nice to be here with you guys, to see it live and be like, what, and discuss it a little bit. They are cowards for not even showing up. I mean, it would have been great if they don't have to say anything, just show up. They're scared. They're scared, don't you think? Mike, thank you for the $5 super sticker. All this time, we don't even know what sneaky Mrs. Laundrie looks like, other than the hat with dark glasses. Was hoping to see them here. Remember that, guys? You guys remember the video where there was that lady outside the Wabasa home, Wabasa Avenue. Never forget that address, huh? With a veil, like a black cat in a veil, all dressed in black. We were like, what is that? What is going on? There's a lot of mystery. Yes, Mike, in this case. We talk quite a lot about that, huh? A lot of mystery in this case, though. It's just, wow. And unfortunately, as Caroline said, Caroline's got some legal experience, I believe. So, yeah, unfortunately, there's no justice. There's no justice in this because Brian is no longer alive, allegedly. I know there's some in here that are like, he's alive. Does anyone in here put a 1 in the chat if you believe he is dead? Put a 2 in the chat if you believe he's still alive. That's going to be an interesting little poll. Yes, we'll send you an email, i.e. the area. Yeah, send me an email, guys, if you want to. I'll do my best to get to it. I can't respond to all of them. It's way too many. I get literally hundreds of emails. So we've got a special guest in the house. This is my email address. I get literally hundreds of emails.
Hello. Oh, hello. Hello.
Okay, hello. Welcome.
Thank you. It's been a long time. How you been?
Yeah, I've been great. Watching your show, loving it. Good on you.
Thank you. I appreciate it. I didn't see your message until just now. I was just I'm supposed to be on another show, and I guess they forgot about me. So, yeah, and it happens. It happens. But I am here. You know what I'm saying?
That's where you're meant to be. Then that's where you're meant to be.
I'm meant to be right
I got
here.
you now. Right?
I'm meant to be right here, right now. Okay, so first off, I didn't get to see the last half, like the ending of it. You know what I mean? So I hate to be the dumb guy in the room, okay, the idiot in the room, but what was the final decision? I mean, are they going to push forward or no?
It will take about 2 weeks for the judge to decide. And don't worry, I've already got the dumb crown. I'm not a legal person at all, not a lawyer. People are like, where are the lawyers in the house? I'm not one of those, so don't worry. I already got that. But the judge will take about 2 weeks to make his decision. That's what they kind of finished off on.
Okay. Well, I mean, they waited almost a year so far, right? So what's 2 more weeks, right?
Right.
To hopefully get some sort of justice for Gabby Petito. But this is it's the whole thing is just trash to me,
Right.
Just the fact that this family, all of us, everybody, I mean, the whole world was watching, at the edge of their seats, just trying to find out where the hell Brian Laundrie was so that we can have some sort of closure and understanding of what the hell happened. Right. And then he just often just kick rocks. He's out on a lamb, supposedly. Right. Actually, I forgot. I'm sorry. But before that, they went on a little trip.
On a little camping trip.
On a little camping trip. How convenient. Where he got to hang out and breathe in that freedom air just a little bit longer. And then all of a sudden he just disappears. And then of course his remains are found in that swamp. But still, to me, it's just like, how can this family continue to get away with it? The one thing that really upsets me more than anything in the world is that they didn't even show up to the courtroom. They didn't even show up to the trial.
The worst, at least. I mean,
Cowards.
after all this, at least, like total cowards, right?
Absolute
dirty laundries. Dirty.
Yeah. dirty laundry. So I mean, I feel like this just confirms their character. The fact that they didn't show up, they let their lawyers, their esquires do their dirty work, instead of actually taking accountability for something, at least something, right?
Just something. I would have been, just to even see them, they would have been like, okay. They've got some dignity left. They got none. They were not there. Oh, man.
So ridiculous. Man.
I just put out a little voter, like a 1 if you guys think he's dead and 2 if he's alive, and there's actually quite a few 2s. Some people still think Brian's alive. You guys are funny.
There are some people out there that think that Elvis and Tupac are still alive too. So, I mean, and Biggie. So anything's possible. Okay?
Tupac's in Cuba. Yeah,
right. He is in Cuba.
Right.
He is
He's
chilling,
in Cuba, having a good time.
having a grand old time.
He's in that photo with Lil Wayne. Okay.
Exactly. But, yeah, I mean, as far as this goes, I mean, his remains are. They found his remains. His remains are what it is, and I mean, I just think that they knew everything. They try to come up with some sort of solution for him. And no, I don't think he. I think his remains are his remains. I don't think he just flew off to Europe or anything like that. I mean, then, that's just some crazy stuff, but some crazy theories that are out here. But I feel like they were really trying to figure out a way to get him out of here. And and this, by them not showing up and not willing to be in the same courtroom as the Petito family, shows to me an admission of guilt. It shows that they were up to nothing. They were up to no good. That's what
Yes. But here again, this is a good point that emotion does not equal law. I also get it doesn't equal law. So they've got a guilty conscience. That's what I can see from their behavior. But unfortunately, it feels to me like this could be dismissed. What do you think? Like the case could be not going to jury trial. And if it does, it's in I think August 2023. Damn.
Yeah, that's
long
enough
time.
Damn. Okay, so all right. Of course, a part of me wants to see justice, right? A huge part of me wants to see justice. I want to see somebody be held accountable for something, but they're not the ones who pulled the trigger. They're not the ones who, I mean, I don't know if they pulled the trigger or not. Sorry. I meant they're not the ones who actually did the heinous things that their son did to Gabby, right?
Yeah.
The only thing that they did that we only know by speculation is maybe try to figure out a way to get him out of here, out of this country, or at least get him out of here. That's all we know. So a part of me is like, okay, they should be held accountable for that, but not be held accountable for the death of their child, not for the death of Gabby. Gabby should
yes,
because the only thing that they did was bear this child, to make Brian Laundrie. If you really think about it, you know what I mean?
Yeah.
But outside of that, they shouldn't be held accountable for somebody else's crimes. They should be held accountable for, trying to help this criminal get away. Yes.
Yeah. Yes.
But anything else? Unfortunately, that's just the reality of it all.
And we don't know if they help clean the van or anything like that. Imagine that.
Obstruction of evidence, so on and so forth. Those things, yes, be held accountable. But if they can prove that, that's
if
the
they
thing.
can.
If they
Which
can
now they can't.
But now it's so old, right?
Once the evidence has been tampered with majorly, they can't do anything.
Yeah.
And remember when there were new stickers on the van? I'm still back. There's still things in this case that I go back to them. Like, wait, what? They were like new stickers put on the van after it arrived at his home. That's so weird.
You're right. I totally forgot about
weird.
that part, man. That's crazy. But yeah,
there's some proof of something.
That's insane. So yeah, obviously there is proof here of something, of some shady dealings, of some wrongdoing on the parents' part, right?
Yes.
But as far as they should be held accountable for something. But for see, and then the other part, oh man, see, it's all coming back to me now like a wave.
Yes, that's what happens. Yep.
The end part, right? The end when they found Brian Laundrie, so Brian Laundrie is out there, out in these wilderness streets, right, doing his thing, in the swamps. Then all of a sudden, the cops give up. Right, this is after weeks and weeks, millions and millions of dollars being spent on on Florida's finest to get out there and try to find him in these wilderness streets. And then all of a sudden they quit. They stopped for a day. Then the very next day, a day after, Brian Laundrie and wifey, say, not Brian Laundrie, I'm sorry. Chris Laundrie and wifey say, hey, we'll go out there and assist you guys in finding our son. They go out there and they go, oh my gosh, look at this, a bag. Oh my God.
Let's pick it up.
A journal. Oh my God. You know what I mean? Like, oh, here is his remains. You know what I mean? To me, it was just kind of like, come on, man. You knew where he was going. Something's not right here.
Yeah, something's not right. This can be a conspiracy case through and through, because it's just like, what the hell happened? This is a good one. Petito should sue Northport for losing Brian to begin with. Yeah. That too. They should do that, because they thought that Roberta was Brian. That was weird.
Yeah, Roberta. They like to call her Roberta. I forgot. It's all coming back to me now. Roberta. I used to call her Roberta. Roberta would right. She was driving the car. Why was she driving the car though? That's the thing.
Yes.
Like all these things that pop up. And then the other thing is like, it was a Mustang, right? It was a Mustang. So the Mustang goes out into the swamp. Like, I'm sorry. This dude is sitting here going, I just need to be one with the swamp.
Yeah.
Instead of I need to be one with nature and I need to be somewhere that's scenic and beautiful, I need to be by the swamp. Mm-hmm. Okay. I need to meditate by the swamp. Does that make sense to you?
Like literally no sense, even though it was one of his favorite spots allegedly to go to. He did take camping equipment, because we saw that from his autopsy results. A flare, a tent, camping equipment, a little box with photos. So it's like, whoa. And they're like, we couldn't stop him. Well, you I don't know. You fetched the car though. It's weird.
It's crazy. I'm sorry. I don't mean to laugh, but it's just, it doesn't make sense to me at all. So obviously they're involved somehow with his escape. Okay. They're involved somehow with his escape. But I don't know what it is. I don't know what the timeline is. I mean, you can always chop up and you can always chop it up and screw it. You know what I mean? You can always flip the narrative around and the pieces will fall in a way that wouldn't make sense. But the only people that really know what happened with Brian
are they?
Is Chris and Roberta. I mean, at the end of the day.
And maybe, do you think his sister knew anything? Maybe not. Maybe she really didn't know too much, because she was like, he acted normal. He was out there having s'mores. I don't know. She doesn't seem to know what was up with Brian.
With Roberta?
Roberta's daughter, right? Cassie.
Oh, Cassie.
I wonder if they knew anything.
I think she knows some things. I honestly think she knows more truth. Because think about it. She went up to that camping site with them to visit Brian and with the kids. It was almost like it was his last goodbye to the kids. So obviously, maybe whilst they're out there making s'mores and fishing and having a grand old time. Maybe the parents and sit down and they tell her what went down, and she's just like, oh my God. And maybe the plan was to get him out of here, to get him as far away as they possibly could. But then maybe the plans didn't work out that way. Or, I mean, there's so many different ways you can break this down. But I think that there was, in a way, that was his opportunity to say goodbye, and then for his sister to know something. She may not know everything, but she knows something.
How can you know nothing at that trip? Like, how can you know nothing?
Thank you. The other question is, you come back home, you don't think, after, doing this cross-country trip and all that stuff, you come back home with the van that's owned by her, under her name, and you know that your brother and his girlfriend went off on this cross-country excursion. You're not going to ask him as soon as you see him for the first time in a long time, hey, how was that trip? What was it like? How's Gabby? Those conversations, those questions aren't going to spark up and be brought up. It seems strange to me. You see what I'm saying?
Yeah. There's also we could go over it all again, because it's just so, all of it. And there's a lot of strange stuff. Even remember when she said, oh, he always does this when he, and then she didn't finish the sentence. And that's now scrubbed from the internet. Have you tried to find it? You can't find that sentence anymore. I'm like, where is it? Like, he always does that when he when he needs medication, when they have a fight, when they what, then he comes home. And still, I really hope that if this case does go to jury trial, then there will be the discovery in between all the documents, right, will be put together. And so maybe if it does, which I don't think it will, I'm fearing it's going to be dismissed. Maybe we'll find out more of what the heck. Did he even really fly home from Utah? Did he fly home? Where's the flights? Like, what happened? Like, oh my word. I know we're all just curious. At the end of the day, we really want justice for Gabby. That's what we want.
I guess
it's
going
to be hard.
The question I guess I have in my mind is like, what would happen? Like, what do they need for it to be worth being brought into trial? Right?
Yeah.
What is that thing? Is it a piece of evidence? Is it just the timeline? With the we just saw Chris mowing the lawn basically the entire damn time, picking up Dunkin' Donuts and stuff from Walmart and everything. It makes you wonder, like, what is it that would be grounds for a proper trial to slap the Laundries with something, because outside of just speculation and hearsay, there is no full-on solid smoking gun evidence, at least from what I've seen, that shows proof positive that they were trying to help him run away. There's no solid proof, unless there's some solid proof out here.
I thought they had it. I was really hoping today that the Petitos lawyer would say, well, we have from the FBI the text that say, hey, Mom, I killed Gabby or whatever, I need help or something. But they don't have that. The way they're basing the fact on that the Laundries knew is literally just because they hired a lawyer on the day that Brian made a call. That's all they know. And I'm like, damn, I was hoping they had more than that.
Yeah. But I mean, wouldn't you lawyer up for your son? Sorry, I'm not, obviously I'm not, I'm go right. Gabby, go all day long. I'm team justice for Gabby all day long. But of course, instantly, that doesn't mean an admission of guilt. That just means that they're smart.
Yeah.
And smart does not mean that they're bad or good. It just means that they're smart and they know the law. So they go and hire, Steve Baloney. I call him Baloney too. Sorry. It's all coming back to me now. Steve Bertolino, right? Steve Bertolini. Steve Bertolini.
Bertolino, yeah.
Is it Bertolino? Yeah,
it's Bertolino, but the Petito lawyer today said Bertolini.
Yeah,
so
he said Bertolini. Okay.
Yeah, Bertolino. Yeah.
But of course, lawyering up does not mean that there's any admission on the family side of guilt.
Exactly.
But maybe they were just doing that instantly because they wanted to protect their son.
And we don't know from what. He could have said, Mom, I'm in trouble, I need a lawyer. We don't know if he said exactly what he did. That's the problem. That's why they need solid proof, like actual text messages or something or the recording of a call, which they'll probably never have, of him actually saying what he did, which I don't think he did, because he lied like anything. He was a great liar from what we see, just from the body cam footage and just things.
It's insane. It's
Dirtolino.
Dirtolino.
That's a good one
too.
Dirtolino, everyone.
I mean, I remember when they first filed for this lawsuit, and Dirtolino, okay, as Annie said, Dirtolino said all their claims are baseless, and that that they have nothing, basically.
Yeah.
But I'm hoping that the judge that they were, of course, doing their basically making their arguments to, I'm hoping that judge sees something worthy of having this kind of trial, and hopefully they can get some sort of peace. The Petito family can get some sort of peace. That's fingers crossed, though, right?
Fingers crossed. It's like, I do worry about it. It seems like legally it's probably going to be dismissed. However, of course, we don't want that. Although if it goes to jury trial, they're not going to get peace for a long time, because it will then go to jury trial. They have to go through all of that. It's quite rough, huh?
Yeah.
Terrible situation to be in.
You said it. It's pretty bad. But you never know. They might find something. The judge might find something. They might find a loophole. They might find some sort of something that they can sit there and go, yes, let's bring this into trial. Let's make this thing happen. And
bring out that notebook.
Right. And that's the other thing too. It's like they're holding all this stuff, right? They Brian Laundrie's estate, okay, which is basically a notebook, for crying out loud, and art supplies. But whatever, if there's things in there, these notebooks and whatnot that show an admission of guilt, I mean, shoot, give them to the Petito family so that they can have some sort of closure, right? So they can move on with their lives. I mean, I know that it's going to be very hard for them to move on because of how this young woman, left this planet. But at the same time, at least they can have some closure, and then they can move forward with their lives, at least,
Yes.
And the fact that they're just holding all these things and they're being so secretive and all that, it just, it's frustrating, man. It's
so frustrating. We can all agree on that, right, guys? Even if you agree or disagree with everything we talk about, I mean, it's very frustrating. And if you were Gabby's parents, what would you do?
Yeah,
that's the question. What would you do? I think they're doing the best they can.
I don't know.
Yes,
I don't know if you know. I don't know if you want to know what I do. Woo! I got friends. Okay, that's what I'm saying. I got friends. Okay, that's all I'm saying.
Oh man,
I'm kidding. But I would heavily contemplate my friends, though. I would heavily utilizing some connections I got. Okay.
Yeah, the Petitos have been especially Joe. I mean, he's been behaving so appropriately. Really holds that anger in real well, because I would be so angry if I was him too. Never mind that they had to fight just to get Gabby's stuff out of their house. Remember that?
Yeah.
Oh, they had to file something in the courts there to get her stuff. That was bad.
I just don't understand why. That's why I mean by it's so frustrating, because I don't understand why a family, why the parents of the murderer would want to keep the victim's belongings. Why would you want to hold on to that stuff? Let the family go in there willy-nilly, or of course, pack up the stuff for them and give it to that family. That is the right thing to do. Why did they have to go get a court order to be able to get the belongings of their dead child? That's crazy. Doesn't make any sense to me.
And they block them, so it's not even like they could just mom to mom or dad to dad talk and say, "Hey, I'm really sorry. Come and get the stuff, or we'll bring it to you." That would be nice. But no, it's like, we're going to block you, and you're going to have to go to court to get the stuff. That's very
insane. That's absolutely insane.
That's what we're saying is outrageous. Yeah,
it's insane. And then, of course, I knew, as soon as, because I started watching the live a little bit. I started watching yours actually a little bit too.
Nice. Thank you.
Hey, when I get a chance to catch it, I catch it. Okay.
Nice.
And y'all are reacting because you're like, wait, the Laundrie family's not going to be there? I heard that. I was like, no. I literally was so angry because, come on. Any opportunity that they can to stay under the radar, they're going to take it.
Exactly.
To me, I feel like they did some bad things. They did some very, very bad things with
They
Brian.
did some very bad things, yeah, and they are unfortunately too good at doing these bad things.
Yes. And that's
They-
what's so damn frustrating about it. But, obviously, we got 2 weeks. 2 weeks
We
to
got
find
2
out if
weeks.
they will be. I mean, and that's the other question I have too. And this is one I wish I had some lawyer friends right now. And maybe
Yeah.
the lawyers in your chat would know this too.
Yeah.
If the judge says, yes, let's continue, let's bring this into trial, will the Laundrie family have to be physically in the courtroom? That's what I'd like. Because why
What
won't
a
they
question.
just
Yeah. Do you guys know? Huh? Would they have to be? They'd probably be via Zoom. I'm assuming they'll be like, oh, it's okay. We'll be via Zoom. Oh, that'll be so frustrating too.
Yeah.
Man.
Yeah.
There might be another whole
Man,
crime.
indeed.
Someone was saying earlier, if they were in the room, they suspected it would be a crime because I think that they're saying that like Joe Petito would just be like,
right,
there they are. I mean, eventually, finally seeing them side by side. Can you imagine the anger? But I have no doubt that the Petitos are very classy, will hold the anger in and behave cordially. So just show up, man. Please just show up.
First off, I can only imagine, right? I can only imagine what any father, any parent would be going through right now, especially if they were in the same space. But you got to remember the anger. Well, no, never mind. I'd be pissed as hell. Never mind.
Right? Yeah, it's like, wait a minute.
Because of what they did. So like, wait a second. No, because, in the back of your mind, as a parent, you're going, you withheld all this stuff. And then on top of that, I had to go out of my way to get a court order to go and get the belongings of my child. Oh my God. It just makes me feel that the Laundrie family is even that more dirty.
Yeah, they're dirty. They can't handle the eyes on them either. Imagine, because those Petitos will be staring them down. I'm sure, especially Joe, he'd be like staring them, and they can't handle it. You see that sometimes, yeah. In courts.
You also got to remember, we haven't heard one syllable, okay, from the Laundries at all, like from the parents, okay. We really haven't heard anything. We haven't heard them speak, right? We haven't heard them really move their mouths and create words, okay. We've only heard from Dirtolino, okay.
Yeah. Laundries, yeah.
So what's interesting is I wonder what kind of interaction the Petito family has had with the Laundrie family before this became a huge national story. Think about it. Parents were wanting to know where their daughter was before anything became national news, right? Before it became such a salacious story and everybody and their mama, including YouTubers like you and me, were on this like white on rice, okay? But it makes you wonder what kind of relationship, what kind of interaction they were having before it became national news. Was Papa Petito on the front lawn of the Laundries, you know what I mean, banging the front door, being like, where's my daughter, kind of stuff? And he's a big mother lover. He a big Popeye chicken eating mother. You know what I'm saying? You're a big dude. You know what I'm saying? Yep. And for a fact, he is one that will, I'm sure he's a great time at a bar. You want to be on the good side if he ever got into a bar fight. But what I'm saying is he's a big guy. Laundrie is not Chris Laundrie is not a very big guy at all. Okay. He's small. So, and frail looking. Okay. So, I mean, from the times that we've seen him push a lawnmower, you know what I'm saying? But you see him pounding on the door, possibly, right? Saying, I'm coming down to you. Anything like that. Clearly, there must have been some sort of interaction that would make the Laundrie family even more reclusive, right? More go into hiding even more, because I just don't see, Papa Petito just being cool with, especially during that time when he's just trying to find out where his daughter is. You see what I'm saying? I feel like he would.
Yeah. Then from the documents, it seemed like they were just trying to call. It seemed from jogging my memory now, from everything I read, because I read those documents line by line. Love documents, but I think he was saying he wasn't on their doorstep. Like all they were trying to do is communicate and call them, and then they got blocked. Facebook, phone numbers, everything blocked. Like, Okay. So that's not great. So they might have already been so cowardly. You didn't have to be on there on the front lawn. They're already just like, oh, I'm scared. Okay, block it.
You
From the
know
start.
what?
That's what the Petitos.
You got a point.
Nice. Yeah.
You got a point there. Wait, what's this?
Yeah, in a trial, they would have to appear to testify, as would the Petitos, who will be grilled about how their emotions were exploited by slimebag attorneys with nice manners. Ew, slimebag attorneys, yeah. So, okay, so that means they would possibly have to then appear in court. That's
okay.
Amazing if they do. Yes.
I really hope so, because they need to be held accountable for something. I mean, obviously, they shouldn't be held accountable for the taking of someone's life, but the fact that they were trying to protect their son. I mean, of course, we don't have any proof of that, but clearly, there's some. It's just something so messed up. He looks pretty active when he was protesting signs from the law. Yeah. So I didn't mean to read your comment. Sorry, but
no, read it. It's funny. It's like I just remember that picture of him. I still love that picture. I've still got it somewhere where he's like sprinting. He's like literally like like the leg is outstretched. He's running.
I mean, he ain't frail when it matters. How's that?
Yeah.
He ain't frail when it matters. You know, when it comes to pulling out signs out of his lawn.
And run. Pull out the sign and run.
Book it. You know, he got to burn off that Dunkin' Donuts somehow.
Right.
You know what I mean? The Dominoes and all the DoorDash that they were getting.
Right.
You know what I mean? But yeah,
I remember all the flowers they got too. Oh my word! And then he came home with flowers the one day too. That was so weird. So many weird things in this case.
It is a very, very weird. And then of course, you know, I want to, you know, we've seen Chris a lot, but I would love to pick Roberta's brain. You know,
yes.
and what this is all. If she has a hand in this, what if she's the mastermind? And Chris is just the wet noodle, just going, okay, dear. You never know. You never know.
And damn, imagine their situation now, just on the side note, because they were going to get a divorce. They were in the proceedings to get divorced. And then all this happened. So now they're kind of in lockdown together, you know?
Oh, I didn't know that. I didn't know that they were about to get divorced.
So now it's like the worst situation possible for them. Imagine it.
Oh man, and now you know how it is. Like in relationships, some people will go and have a baby just to keep the relationship together. Right. Well, I mean, I guess they got a murder. That's
right.
Murder, baby. That's so crazy. That's keeping them together. They're in hell, basically. They were going to each other. Wow.
Yeah, that's from when the case broke. That's allegedly what I had read, is that they were actually going to get a divorce. And then it's like, man, imagine this, being forced to be together in this situation.
Yeah. No, this is exactly what they deserve.
And it's like escape room at the worst level.
Absolutely. Drive each other nuts. You know what I mean? Don't get divorced. Stay in hell. Stay in that hell. Please. This is exactly what you deserve. This is the bed that you made, Laundries.
It's kind of a little bit of justice already, huh? A little bit. I mean, a little bit of karma going on there. Like, damn, that's a bad situation.
Yeah, a little bit. Because you know for a fact they're probably blaming each other for something. You know what I'm saying? Right. They're blaming. They're pointing the blame at someone. Someone had to spearhead this whole plan. Unless it really was, they woke up one day and Brian literally left. But other than that, somebody had to come up with this idea.
Right. Sorry, I'm laughing at this comment now.
Whipped.
Maybe. Yeah, whipped.
You probably ain't wrong. You know what I'm saying? That's probably why he was mowing that lawn, because she said so. She's like,
better mow that lawn.
Exactly. Honey, this pupper, just mow it.
Take out the trash and mow that lawn and pick me up some Dunkin'
Donuts.
Go! Right? Oh man, I need my Dunkin' Donuts now.
Oops. You know what I mean?
Some flowers.
Oh my god,
he really is there. God. Here's Doug. You know Doug from Northport, Florida. He's there at the house.
Wait, are they still in this house?
They're still in this house.
I thought they moved, yo.
Crazy. Okay, so
man,
very
stop!
Quiet.
Stop! Gisela, stop! You tell me they still live in that house?
That's crazy, right? Why don't they get themselves out the country if they were trying to help their son?
Go. Yeah, they got a canoe. Just canoe across the river. You know, across the ocean. You know what I'm saying? And just, you know, we'll pray for you. Not really, but you know what I'm saying? Damn. For real?
Damn, people. Right? They're still there. Look at that.
Oh
There's
my-
the car. Car is still there. 4343 Wabasa Avenue, everyone. We know it.
Wow. I thought I figured it would be vandalized or like graffitied or egged every single day. I mean, the anniversary is coming up soon, right? September. It's in September.
Yeah.
Oh man. Oh my God. Oh my.
Only 90 miles to Cuba. Go hang out with Tupac, everyone. You can go there.
Just go. You know what I'm saying? You got some. You can eat. Hey, they love to glamp. They love glamping.
Yeah, they love the
You know what I'm saying?
glamping.
So just go kick rocks. Just leave the country.
Man.
Leave us, please.
It's amazing how they just sit
That's
there,
not
because
funny.
if they were such criminal masterminds, it's like they say they're like, oh, they're bad. They know what they're doing. You know, they're playing the legal system. Well, why are you still sitting in this house?
Right. Why are you still there? I thought they
You
tried
can
to
go anywhere.
I could have sworn they tried to I thought they were trying to move. I heard
No.
I could have sworn I saw
Remember that for sale sign in front of the lawn? That was fake. It was photoshopped in by someone. I don't know who.
Okay.
Yeah.
Okay.
That day I actually
Cool.
photoshopped one in myself to prove how easy it is. I was like, look, guys, I can just put a sign on here, and I showed them because it was literally not. They I don't think they made a statement. Someone said, no, that's just false. It's just rumors. They're not actually selling the house.
Oh my
Damn.
God. I'm so upset.
They can't leave because Brian's in the garden bed.
Right.
They can't go. The baby boy is still there. He's asking for snacks.
You got
Exactly.
me messed up. No, the evidence is still in there. The evidence is still in that bed. Watch.
Right.
Some of his body is in there.
Right.
That's the only theory I have in my head is that they took the book bags, they took a part of his face.
Yeah.
And the book, the book bag, the book, and some camping gear, and then they just went out there and just, put it out. Somebody took a walk, put it out there, and then said, "Okay,
there he is."
There he is. 2 days later, oh my god, there's some bone right there. Oh my gosh,
right?
Oh no,
oh man,
my baby. Lo siento.
With one tear quickly. Remember the one tear? We only saw Chris from behind, and then Roberta just wiped that one tear.
Yes,
Damn.
that one tear, which could have been sweat because it was hot.
It was hot. Yeah.
Let's not forget that. It could have been sweat.
Right. Right.
Then on top of that, he took his own life with his left hand.
That was weird. I have a lot of theories about that. They're not so pretty. I'm just like, why? So what was he doing with his right hand then? And based on the books he was reading, I went there.
Wait. Time out. Stop. Now we get.
What was he doing?
Hold up.
Maybe he was holding a photo. That's all I was saying. What are you saying? I was like, based on a book he was reading, you just don't know what he was doing.
Oh my God. Okay. Based on the, he might have been ambidextrous.
He may have been. Yeah.
He could have been that too. You know what I'm saying? He might have been able to, the left
Weird
hand
choice.
may not know what the right hand is doing. You know what I'm saying?
Yeah.
Anything could have been possible, but yeah, all that is there's too many speculations and
yes.
I'm so confused.
Me too. Everyone. We're all confused. Well, maybe some people aren't. For them, it's cut and dry and legal, but I'm confused still. There's still so much that wait, what was that?
Yeah.
We don't know yet, guys. We don't know yet. 2 weeks. 2 weeks.
Oh yeah. 2 weeks, y'all. I just found that out too. Okay.
Yeah. Learned it right here. 2 weeks, we'll find out. Within 2 weeks, so it could even be sooner. But in about 2 weeks, we'll find out the judge's decision.
Well, dagnabbit. I hope that they get. I want them to. I want to see justice. I want to see.
Yes.
I want to see some justice because or something. I just want to see closure because there's no closure. I mean, yes, him did. Okay, great. Him did. Fantastic. We were, ding dong. That son of a gun is gone. Okay. Yay. But at the same time, there's no closure. There's no explanation. There's no timelines. There's no storylines. There's no nothing. All we have is speculation and theories. Yeah. And I'm worried that this will be one of those stories that we never will fully get the full answer to, like Harmony Montgomery, or the Delphi murders, or a slew of other things. There's all these theories revolving around those other murders, but at the same time, we don't have solid evidence. We know who did it, but we don't know why and how. All we have is speculation. And then, of course, the relationship between Brian and Chris and Roberta, we don't have any of that as well. So it's frustrating.
It's so frustrating, man. Did that other show get back to you yet, or what?
It looks like they did. It looks like they did. So I'll be hopping on over there. And
Do it. I'll be excited. I think I know where you're going. I'm excited to see you there.
They forgot about me, so you know it happened.
Have a word with them.
No. It's fine. It's the first time. You know what I mean?
Yeah.
The first time sometimes it's sloppy. You know, I'm sorry. It's our first
It happens. A lot to organize.
You know what I mean?
Yes.
Lots of.
I'll be excited to see you there. I'm thinking I know where it is. Guys, go on the hunt. We'll find him.
Yes.
Right.
But hey, I appreciate you. Let me hop on. I miss you, man. I miss you. We've been, sending DMs back and forth, but we need to make this happen more often. And
absolutely
I'd over on my channel too. So let's make that damn thing happen. You know what I'm saying?
Let's make that damn thing happen. Twitter, Instagram, whatever.
Yeah,
we'll chat. We'll keep chatting.
You know what I mean? All right.
Yes. All right. Well, thank you for being here. Tell us.
One thing that will make me really happy. Okay, so and I'm just going to invite you live, and then everybody who's watching.
Oh, nice.
Not okay, but all the Grizzlies that are listening and watching right now as well. I'm going to be doing a birthday stream on Friday. I'm celebrating my birthday.
Oh, damn! I'm so excited.
So
It's like a celebration weekend. On Sunday, I'm celebrating my 1 year over here, as in 1 year on Grizzly True Crime.
Oh, I thought it was like, marriage.
Oh, hell no. It's just, well, I am married. I'm like, oh, hell no, I am married.
Oh, no.
Like,
you've been married for a while. Okay.
Right. Yes.
No,
so 1 year since I started Grizzly True Crime on Sunday. So it's like a celebration weekend. So if you want to hop on Sunday on my stream too, you could do that. We could party all weekend.
Yeah. Let's go.
Yeah.
Let's go. Now I'm going to have some cake for this is gonna be a bad day.
Yeah, what am I bringing?
Lots of cheat meals. Okay. Friday, celebrating my birthday. Doing a live stream birthday thing. 10 a.m. Central Standard Time. 11 a.m. Eastern Standard Time.
I was worried about the time for a second because I'm in the Netherlands and I'm like, oh damn, but I'm on Utah time at the moment, basically, because I'm just like up until 4 or 5.
I don't know how you do it. I need at least a few hours before I go berserk. So what time is it? What time is
11
it?
For you, 11. It's 11 Eastern time on Friday, right?
Yeah.
12, 1, 2, 3, 4, 5. 5 o'clock my time. 5 p.m.
Oh, 5 p.m. Okay, I was going to say 5 a.m.
5 p.m.
5 p.m. Okay, it's not bad.
I'll bring my G&T and party hard. They like we all still say it. Partying hard over there.
Party horde. Horde 41.
Yeah.
The horde 41.
So it's the horde.
Now the thing is so you will be the one lit as hell because it'll be my birthday. So
I'll be partying for all of us.
I'll be celebrating my birthday. So in the morning. So I won't be drinking yet.
I'll have a G&T for you there.
The word yet, but it'll be 5 o'clock in your world. So in your neck of the woods. So hey, let's get.
I'll bring my mega pint.
Please bring your mega pint.
A mega pint is coming. Yeah, a mega pint. I'll be bringing that.
Fecal matter.
Yeah.
Fecal matter in the bed.
Oh man, you covered that so well.
It's a blessing.
Favorite coverage of that. Oh my gosh.
Oh, thank you. It was a lot of fun. It was a lot of fun just acting a fool. I mean, it was the gift that kept on. It was like Christmas every day.
Really? Every day. You were like, I'm wrapping this up, guys. I'm done unless. And the next day you're like, she lied again.
She lied again.
You were like, the very next day she did her immediate. You're like, here we are again.
Yeah, I'm like, damn. Like I need to breathe. I need a moment to not have to talk about that daggone woman. You know, and it would just be another story. I'm like, oh man, again. Okay, we're at it again, I guess. You know what I mean? So, man. But anyway, it's been a lot of fun, and it's been.
Yeah, I'll be honored to hop on Friday. I'll be honored to celebrate your birthday with you.
Friday, please definitely come through. That'd be a lot of fun. I'll definitely message you throughout the next couple of days, just so I can, to confirm things.
Don't be sloppy now.
No,
sloppy now.
No. I won't be getting sloppy now. Okay. No, not until later. Not until
later. Yeah.
Not on the show, but and it's 10 o'clock in the morning for me, so I'll be busy drinking coffee and trying to just be alive.
Nice.
You know what I mean?
Nice.
So, but Gisela, thank you so much for letting me be on. I appreciate it. And
thank you for being here. And I'm gonna have a peek when you go now. Where you're going next? Are you going over to?
Yeah, I'm gonna hop on in like 5 minutes. Yeah.
Do it. Can't wait.
Yeah, I'm gonna hop over. I don't know what they're talking about, but it should be entertaining. You know.
Don't worry. If I could do it, you could do it. I was there, like, hey.
If I crash and burn, I crash and burn. Let's go. You know what I mean?
You're gonna do great.
Thank you. I appreciate it. All right, now. Well, then I will talk to you very soon. All right.
Okay, cool. Thank you for being here. I'll say bye to the Grizzlies now in a moment, and I'll talk to you behind the scenes.
Okay. See you soon.
Bye, Pascal.
Bye.
Peace. Bye, Grizzlies. Thank you so much for being here for the stream. I really appreciate it. Hold on 1 second, Pascal. Ooh. Thank you for being here for today's stream. I really, really appreciate it. Thank you for all the support, for all the super stickers. I'm so sorry, mods. That was like way over time. I'm so sorry. Look. I'm going to say thank you so much to mods and special ops team. Special ops knows what they are, because some people are like, what is that? Don't worry. They know who they are. I see Doug driving around. He's on my other screen here. Very cool. I hope you guys enjoyed the stream. It was amazing to, waffle time is Stewie. Exactly. That's what we're doing now. Thank you all for being here. Waffle time is now. I'm going to go and see. I think Pascal's going to be on Popcorn Planet now, from what I know, a little bit from the grapevine, I think. So let's go check it out over there if he is. Thank you. Thank you so much, Aaron. That's so sweet. This was way over time. Very interesting stuff. Closing thoughts. Let's see. I do not think either Gabby or Brian were even close to ready to be adults. I figure that size matters. Either could have been a killer if they were the same size. Wow. Yeah. I don't know. Oh, and before I forget, I always forget to finish the poll. So let's see what you guys said. Do you think this case will go to jury trial? 47% said yes, it will. 14% said no way, it'll be dismissed. 38% said not sure, and 1% said what case. Now, 47% think it will go to jury trial. 38% think who knows. Okay, I understand. But only 14% think it will be dismissed. Well, that's good to know. Well, I'm thinking I'm afraid it's going to be dismissed, but I really hope it will not. Okay. Hey, Dog Defender's in the house as well. Thank you, everyone. Last thought, if you haven't seen my second channel, it's called Grizzly Antidote. It's under my recommended channels as well. Please go check that out. Subscribe over there. Hit the thumbs up there. I cover entertainment news. Yes. So, I'm guessing I'll be on Pascal's show on Friday. And tomorrow, I'm live here again with Chris from The Monsters Under Our Bed. He's got some exclusive footage for us. They made it out there. They went out, car broke down, came back, got towed back. And then they went out again the next day and actually got some really great footage in searching for Dylan Rounds. Of course, Chris and his cousin Nick are literally like trying to help find Dylan, or any evidence or anything, of course. We will be looking at some of that footage tomorrow. Very special footage. Looking forward to it. Thank you, everyone. I appreciate you. Now let's play that outro, shall we? Did I miss anything? Let's end the poll because I need to click that. So tomorrow, live. Friday, I'll be on the Pascal show. And then on Sunday, we're doing the 1 year celebration. Yes, we are. 1 year since I started Grizzly True Crime. That's quite a milestone for me. It means a lot to me. So thank you all for being here. We reached 44,000 subscribers yesterday, I think. So thank you all for subscribing. If you haven't yet, or if you look, just make sure you are subscribed, because sometimes YouTube unsubscribes you, okay? Subscribe, hit the thumbs up, and I'll see you very soon.